Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. Oh, wait, I've got this on the wrong way. There we go. I am your host. That's terrible, too. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. I'm absurdly bad at this. Leave me alone. I'm trying out a new thing today where I just steal the implementation of StreamYard, but don't actually broadcast through StreamYard because I boomered the link. So.
Yeah. And they can see the little sub windows below our main windows. So they get to see the full interface and everything.
If you want to see how StreamYard works, and by the way, it's a great system. Everybody should try it. You can see it right here. But no, so I have today as a guest, Uncivil Law. Welcome to the stream, sir.
During daylight hours, as we can see, as the sun shines upon me. And it's going to get only brighter as the sun moves.
Well, it'll be bright in the face of our darkness, which will be nice.
I'm going from white to more white as the sun moves position. So yeah,
it's like moving from I don't know, France up to Ireland or whatever.
Right.
So we are going to do some fun time streaming today. We're going to continue yesterday what I started, which was the oral arguments in this Pennsylvania case that the Trump team did not prevail in at the moment. And I want to talk about that a little bit before we get started, because I've received a mild amount of pushback, and I'm not intending to yell at or berate anybody in the chat. That is not the goal. That may be the effect, but it's not the goal. Here's the question.
Yeah.
Did the Trump team lose this case on purpose to go to the Supreme Court?
Well, if so, I think it's a very bad strategy, because that's not going to happen. Even
if the prospect was good to go to the Supreme Court, would it be a good strategy to lose the lower case on purpose with the idea of going to the Supreme Court? Have you ever? Can you conceive of a time where that would be a good plan?
Well, I can conceive of times where you would know that would happen because you're flying right in the face of Supreme Court precedent, for example. I mean, Brown versus Board would be a good example, right? I mean, when Brown versus Board is filed, you know you're going to lose until you get to the Supreme Court, because you're flying right in the face of Plessy versus Ferguson at that point.
So you're going to make a public policy argument to get the court to reconsider stare decisis on a major issue.
So I can definitely conceive of situations where you know you're going to lose. What I don't think is a particularly good idea is I'd like to go to the Supreme Court on a claim of fraud, and then I'd also like to drop that from my complaint so that I never raise the issue at the lower court, because that sounds like a thing the Supreme Court's going to let me do, bring up an issue that wasn't preserved. That definitely seems like a thing that's going to happen.
Yeah, I think people have it's not their fault that they don't understand appellate procedure and appellate reality.
Yeah.
But the main underlying issue of this line of thinking is that whatever you do bring with you to the Supreme Court, you have to bring with you. You can't just try and get your issue in front of the Supreme Court and then suddenly be like, haha, new arguments. It doesn't work that way. It's not an interesting rope-a-dope or whatever. So given the premise that maybe they did try to throw the case, because that was the press release, right? Well, we're happy that they dismissed this because now we can kick it up the chain faster. My thoughts are always, if a federal court has the power to enjoin an election certification, it's better to do it at the lower court and delay the certification, because that's their ultimate goal, is delay certification beyond the electors. And so if you can potentially get that win early, that's a better strategy than going into a loss. But even if the plan was to go to a loss, doing it with the ammo that they've left in their complaint is really a terrible idea.
Yeah, I can't agree more. You know, when you appeal things, if you don't preserve it, you lose it. If you don't preserve facts, you lose it. If you don't object when you needed to object, you lose it. If you don't raise a legal issue, you lose it. So you can only come to the Supreme Court with what you started with. The only exception to that is subject matter jurisdiction, where you can raise that issue for the first time, that the court can't hear the case because they never could hear the case in the first place. But other than that, you can't raise a new issue. So yeah, what you come to the Supreme Court is what you come with, and the facts are the facts, and the law is the law. And if you didn't preserve it below, you're done. And I'm having a very hard time understanding the strategy of let's just get to the Supreme Court and they're going to do something, because that feels like a thing that is not going to happen. You want the Supreme Court to intervene and make a ruling that's going to dramatically change the election without any sort of underlying thing happening before that. That's just not going to happen. I'd be honestly amazed at this point if the Supreme Court actually hears any of these cases on the merits, because one of the nice things about being the Supreme Court is you have discretionary review on appeals. So if all the cases are lost at the district court and all the cases are lost at the Court of Appeals, why would you, the Supreme Court, decide to hear this case and get involved and render any decision at all, which can't be perceived as anything other than political, when you don't have to? Why even bother? So I'd be amazed if the Supreme Court grants certiorari on any of these cases at this point.
Yeah, it's because it's a different story if they had won a significant percentage of cases. So they got 4 states. Let's say they lose 3 states in different circuits, win in a different state in another circuit. Now they've got a circuit split on potentially similar issues. Right. They take that to the Supreme Court, and the Supreme Court now has to resolve a circuit split to decide an election. That is a potential avenue. Right. Unfortunately, they haven't.
Or if the Trump campaign had won at a court of appeals and a federal court had intervened and issued an injunction, I could see the Supreme Court getting involved to undo that, so they could get involved to strike that down. But if the Trump campaign doesn't win below, why? I mean, the only legally interesting issue to me and to the legal community really is the ballots that were received after Election Day in Pennsylvania, because there's state law issues there and there's some interesting federal law issues. But you're talking about maybe 10,000 ballots, and Trump is winning by 80,000 votes. So sure, we could have an esoteric legal argument over whether those 10,000 votes should or shouldn't be counted, but why bother when it won't make a difference?
Right, and that's if there is a possibility to still go to the Supreme Court after the election is decided. If there's an issue that will that could present itself at the next election, that could be resolved. For example, if state law or if state statutes governing the rules of elections violate the Elections and Electors Clause, but wouldn't have an impact on this election, it could theoretically go to the Supreme Court over the next year or 2 years, and we could have that issue resolved by the time we get to 2024. And that might be an issue for the Supreme Court to take up. But to actually overturn this election, their prospects are getting lower and lower and lower, and it's literally by the minute now. Yeah. Which is why Sidney Powell is delightful lately. I don't know what else to say, because I don't know the lady. I don't know her work. She seems to be doing okay on Flynn for a while.
Yeah, I mean, I think she has it solid on Flynn, and so I think it was Nate Brody this morning or one of the people in the chat who was saying maybe she got suckered in to the whole conspiracy world as part of her involvement on Flynn. Because Flynn, I think you can make a very credible case that there was a conspiracy against Flynn, and he got jacked by the FBI, and they set him up, and the whole thing was kind of poisoned from day one. So I think that conspiracy makes sense. And then maybe because she went that far, then she went to the next levels of conspiracy land where it made less sense. Yeah. So maybe that's what happened. I don't know.
Now I'm just waiting for my biblical steroid-infused Kraken to arrive. Yeah. But the problem with this, I saw something, somebody retweeted it today. I don't think it was Barnes, but it was no, it wasn't Barnes. It was a non-lawyer, I believe, and they had retweeted Sidney's stuff, and there's some PhD guy who created Overstock.com, and he's now saying he has conclusive proof of cheating via software. He's had it for 14 to 15 days. And
you know what would have been helpful if you told us about that about 14 or 15 days ago? That would have been helpful.
And what they're just trying to do now is explain it to the boomer lawyers so they can go explain it to a boomer judge. And all the problem with this is it all rings hollow because that, like you said, we needed that 15 days ago when you had it. You got to get on the phone. Like, you're the CEO of overstock.com. You're not an unconnected person. You call up one of these campaigns or hotlines or whatever, and you say, look, I can conclusively prove this through software. Then you get on the phone. You don't wait 2 weeks to do it.
Or just put it into the public domain. That would work too, presumably.
Right. That's the other option.
It's not like the evidence will become any good, better, or worse by just being dumped into the public. Be like, here it is, public. Here's my conclusive evidence. If the evidence is good or bad, I mean, it's not going to become any better or worse.
Right.
So, yeah.
And the last subject I wanted to get to right before we got started. This one was retweeted by Barnes, although in a different context. Did you see the decision that came out of Michigan? I think it was today.
I have not yet. No. Is this dealing with the certifications and all that good stuff?
It is.
I mean, I saw them certify it, but I didn't. Was there a legal decision?
There was a legal decision.
Ooh.
It's let me pull it up. I can actually.
You can actually share it and put it on screen, and we can laugh at it together.
I can. I'll do that.
Theoretically.
Hypothetically laugh. Let's see.
Well, I mean, hypothetically put it on screen.
No, I've got it here. Let me see if I can get it. I got to see now if it's centered in the window. This is a problem with doing this like a hack job.
We'll do it live, man. We'll do it live.
Yeah. Okay, so this is the City of Detroit Election Commission, Detroit City Clerk, Wayne County Clerk, all of these people, right? And
versus
this
McCall. All right.
Right.
What do you got for us, Mr. McCall?
So, there's some good and bad in here. I will say this. And Barnes talks about some good stuff. His tweet was quoting right here. Every citizen in the United States who's an elector qualified to vote in Michigan has the right to have the results of statewide elections audited in such a manner as prescribed by law to ensure the accuracy and integrity of elections. So what the judge does here is he determines that a pre-certification audit is meaningless. If people remember, the Republican canvassers wanted to hold out certification pending an audit of the votes. And this judge says pre-certification audit doesn't make sense because what are you auditing if you're not auditing official results? Fair. So he says they should have access to an audit. But here's the but. What the plaintiffs have failed to do is establish how this version of they're entitled to this version of an audit over the standard audit practice that's already going to take place post-certification. And they're
right.
distinguished.
Yeah, you have the right to results of a statewide audit.
Right.
So whatever that process is, you have the right to those results. So if there's already an audit process in place and that's already happened, then yeah, you're entitled to the results. So I basically interpret that as a FOIA. It's freedom of information. Here you go. Here are the results. Yeah,
and there's two specific. There's the type of audit they requested, and then there's the type of audit that's provided for automatically under Michigan law. And basically, he says there is no specific right to a particular type of audit, just that an audit be provided for under Michigan law, which it is. So that's the balance to that one. But I want to focus on this paragraph right here. Even so, while plaintiffs are not precluded from seeking a future results audit under Constitutional 1963 Article 2, Section 41H, the certification of the election results in Wayne County has rendered the instant case moot to the extent that plaintiffs asked this court to enjoin that certification. There's no longer anything to enjoin. While it is noteworthy that two members of the board later sought to rescind their votes for certification, we'll skip the citation, plaintiffs have nonetheless provided no support, and I have found none, for their proposition that this affects a decertification of the county's election results. So I just want to update the people who screamed at me that they had definitely decertified the results and that they definitely have a right to do so, that there isn't a legal authority that allows them the right to undo their vote once cast for the canvassing board. even though they claim it's under duress. It may be under duress, but there isn't, and the Republicans have not provided any legal authority to suggest that they can. So I tried to tell you. I don't mean to be the doom pill. I really don't. In fact, I brought Uncivil Law on to be the other doom pill, so we can just half pill everybody.
I'm all about the doom pill,
but,
as well as pretty much every court that's looked at this stuff so far. So what is this? 24, 25, 26 cases that have been dismissed at this point. It's hard to keep track.
I don't like the argument that the number of dismissals, especially in so many disparate cases and disparate jurisdictions, amounts to proof that they don't have anything. But what I will say is that it's
not exactly encouraging.
It's not encouraging, and it's certainly indicative that what I've been saying, and I think what you've been saying all along, is that this is, even if correct, these are really hard cases to get in front of a court because it's a political process and you're asking for judicial intervention over that political process, which might in and of itself be violative of the Article 3 court powers to do so.
Yeah, right, exactly. I mean, this is a big point I make on my channel where I try to separate political and legal as concepts, as separate concepts, and the two should try to stay away from each other. And so the idea of going to the legal branch to correct political issues is kind of a non-starter almost for me. And so people try to address these up in legal issues. But the problem is that the case law out there doesn't really allow that. The case law is out there, and I was trying to find the exact language earlier because I know that there's a citation for this. But basically, when there's these kind of routine election ambiguities or routine election problems, that's not an equal protection issue. So people are like, oh, this is equal protection because some voters are being treated differently. And the courts have said, look, in every election, there's something somewhere where someone did something they weren't supposed to. But these routine, normal things does not an equal protection claim mean. You need more. And the ones that have been documented are fairly routine, like the people who didn't have their votes, they didn't have an opportunity to cure. Okay, well, at best, we could give you the remedy of curing your ballots for, the remedy it would give you.
Right.
But, we're not going to do more than that. And a lot of the evidence that's been presented has been dismissed by the courts because they found it to be non-credible when compared with other evidence. They've, especially on an injunction, because injunctions are considered to be an extraordinary remedy, a disfavored remedy. And so when you're coming on injunction, you're doing the 4-factor test, and you're looking at this evidence, it's kind of weak, and you're looking at the other evidence, it's like, I'm not going to grant an injunction. That's the result you would expect. So I don't know why people, and also I just point out that this has also been done by both parties. It depends who won. If 4 years ago, the Democrats were saying all kinds of negative things about how elections were tainted, there was a great compilation done by somebody, and I'm still looking to find it again, where they documented like every blue check mark and every Democrat over like the last couple of years, and they all saying how mail-in ballots are horrible, how electronic voting is how horrible. The New York Times, like 4 years ago, did a wonderful op-ed on the 7 ways election voting is unsecure. Here's how to protect your mail-in ballot, and so forth and so on. And you might remember, if you can remember back 3 months ago, the Democrats were even saying how Trump was trying to interfere with the election by removing automatic sorting machines at post offices and directing the post office not to deliver ballots, and how he was trying to corrupt the election. And what do you know? 3 months later, it's the most secure election of all time, right? Everyone flips talking points all the time. The Republicans are screaming about the election voting, the electronic voting now. The Democrats were screaming about Diebold, back in the day, and how that was corrupt for electronic voting. So it's like these election disputes are not new, at least in my humble opinion. They're not new, and they're not of a different scale or size to the kind of thing that, because you're dealing with every separate state, and not just that, but every separate county, and not just that, but every separate precinct. I don't even know how many election precincts there are in the United States. Lots. But when you're dealing with 50,000, 60,000 precincts, things happen, and not everything does an equal protection claim meet. You know what? It would have been better if more Republicans had voted or they had, or the Republicans had made such a problem about voting by mail. Maybe they should have said voting by mail is cool, and we'd like to have more people voting by mail, and then more of the ballots that came in by mail would have been Republican. That might have been nice. So there were issues there that could have been resolved.
There are. And to add on to one thing you were saying, even in this election, we've got Republicans, the Trump campaign, arguing against its own equal protection argument in Harris County. Right. With the exact same set of circumstances, where in Harris County there was a provision for, did you cover this case on your channel? I feel like you did.
I might have.
Where there was, they allowed for basically a drive-up drop box for ballots. But in Harris County, which comprised like 4 million people, they put like one up. And the Democrats in
with the drop by ballot, I did absolutely cover that case, and the Fifth Circuit Court of Appeals threw that out because it's like they've given you more than you had before.
Yeah, exactly.
They gave you more. And you used to have zero drop boxes. Under the old law, you had, if you were going to drop them off in person, it had to be on election day. So you had 1 day to drop them off in person, and there used to be 0 boxes. You had to drop them off at your voting location. The Texas government extended that to, instead of 1 day, how about 40 days? And instead of at your voting location, how about this drop-off location? And they said, well, that's not fair because we had more than 1 box and they took away some of the boxes. And the Fifth Circuit Court of Appeals said, what are you talking about? They only gave you more than you had before.
Right.
That's not diminishing your rights. That's an extension. 1 is more than 0.
And that's that was the Republican argument in that case,
right,
if I'm not mistaken.
It was completely right.
And it's if you take that argument up to this case in Pennsylvania, where they're saying, look, some people got an opportunity to cure. It's like, well, that's an extra thing. That's not a restriction on your vote. That's an extra opportunity to ensure your rights. So whether you agree or not with it, the way the court is going to look at it is this is an expansion of rights, which is permissive, and therefore you have to show a very significant difference in outcome, not just a difference in how they're treated through this, that you have to show that this has a disproportionate impact, I guess, on a particular voter, a particular group of voters, or a particular candidate. And until you do that, you're like sitting, you're in an eclipse.
I'm trying to deal with it's either that or bright white. What's your choice? You want me to deal with the eclipse, or you just want to deal with unfiltered bright white?
It's up to you. Doesn't bother
we'll just
me
go back the other way.
Whatever you're comfortable with.
My poor eyes. I'm gonna have to put on sunglasses because my damn eyes can't take it.
But yeah. So the hard part about this stuff is one, there's 2 things going on here, and I think the last ditch effort is what they're really going for. And to me, that last ditch effort is to try and rally enough Republican support in the states and in the federal Congress to decertify the electors. Good luck with that
plan. Good luck with that plan.
Yeah, you mentioned this in the SALT video that it would be it would dump all the political capital that the Republican Party has. And I know people say the Republican Party doesn't have any political capital or whatever. They actually do still control the Senate. And if they did that, it would be a short bus to Democrat rule for quite a long time.
Well, I mean, it's so anti-democratic and so anti the values that we stand for that even though I'm right-leaning and conservative-leaning, if they did that without any reason, I'd consider rioting in the streets at that point, because you can't just disenfranchise people for absolutely no reason.
Right.
Even the legality issues are one thing, but it cannot possibly be politically tolerated. And I mean, and what I say to people is just imagine it went the other way. Just imagine that 4 years ago, states were trying to not recognize Trump or present other electors. Or 4 years ago, the United States Congress decided to de-recognize states and invoke the 12th Amendment to put Hillary in office. How do you imagine that working out for the right? And so if you do that to the right and you're talking about doing that to the left now, how do you expect them to react? Not well. And so I cannot begin to imagine that there's any incentive from anyone to provide any kind of challenge. I'd be amazed. You know,
It would be devastating to the right
I mean,
politically.
at that point, we're talking about the devolution of the republic. At that point, to be quite honest, we're talking about full blown civil war. I think.
Yes, very, very much, because it's, and we would have been talking about full blown civil war had they done it in 2016 as well, and they talked
Right.
about it. I mean, it was
Yes, they did.
discussed as a legitimate
There
possibility.
were full on campaigns. There were TV ads. Martin Short started a TV ad 4 years ago about how the electors should vote their conscience. And members of the Electoral College, you don't have to vote for Trump. You can vote your conscience. They ran full bore advertising campaigns 4 years ago.
Yep.
On the count day on January the 6th of 2016 or 2017, apologize. January 6th of 2017, there were Democrat members of the House standing up and saying, I have a challenge. I want to challenge. And Joe Biden, who was president of the Senate because he was VP at the time, was saying, you know, is there any senator who wants to do this? And they said no. And so it's over. It's over. It's like, you know, maybe it would be good. And I was saying there was that woman who famously, who was wearing that like yellow safety coat at the inauguration day, who was yelling into the wind. I was like, you know what might be good? Maybe the Republicans shouldn't do that as much. You know, I kept an open mind initially. I thought, especially in the early days, because it looked a lot closer than it wound up being. And, you know, I don't know. And so I don't begrudge anyone legal rights. You know, I think legal rights are fine. That's why I became a lawyer, right?
Right.
But as more evidence came to light because the election results became in, and as court proceedings went on, it's like, well, I'm not seeing anything. I'm certainly not seeing anything that's going to change this result. So, you know, I think it's in the Republicans' interest, and I say this as a Republican, as a conservative. I think it's in our interest to, you know, to admit this particular defeat and also revel in the success that we had, because we had quite a lot. We picked up at least 9 House seats. There are 4 that contested. I think all 4 are going to be Republican. So we picked up 13 House seats. That means I think we're talking about a 5-vote difference in the House. So we're talking about something like 223 to 217 or something in that ballpark in terms of the split in the House. It's very narrowly Democrat. I think there's a decent chance Nancy Pelosi doesn't keep the speakership at this point. If the Republicans keep the Senate, which I God hope they will, then the worst excesses of the Biden administration will be curbed. So we won't have to deal with the really radical people in a lot of cabinet spots, even Attorney General, Health and Human Services. That's going to be a big point with all the lockdowns. Mm-hmm. Homeland Security, Department of Defense. I mean, that makes a huge difference. The Republicans also picked up quite a few state legislatures. They picked up 3 state legislatures. I think they're up to like 29 state legislatures in that they have control of now. That helps huge with redistricting. And also in the election, the Republicans picked up, for Trump, they picked up 5% more of the African-American vote than they had in the past. They picked up something like 12% more of the Hispanic vote. They had an all-time record for overall minority vote, 26% of the overall minority vote. That's a record. Mm-hmm. It wasn't minority vote that killed the Republicans. It was suburban white women who principally killed the election. In the inner cities, including Philadelphia for that matter, including Miami-Dade, Trump overperformed. So it was principally white suburban women who changed the election result, as best as I can tell. But what it means to me, it means a couple things. First of all, without more, in a typical year, in a typical midterm, you expect the midterms to go against the president. That's pretty typical for the midterms to go against the president. Yep. So if Biden winds up being inaugurated, and I think that's going to happen, you would anticipate the Republicans to pick up votes. So I think there's a very decent chance of picking up the House in 2 years. Mm-hmm. The Republicans hopefully will have 52 votes in the Senate coming in, and hopefully they'll pick up more because there are more Democrat seats open in 2 years in the Senate than there are Republican seats. So you'd anticipate them to pick up more seats. So maybe 55 votes in the House, or 55 votes in the Senate. So they might flip the House. They'll get to 55 votes in the Senate. And then 4 years from now, I think Biden is kind of a weak candidate. He probably
he's
won't
dead
run for
already.
Yeah, he won't.
He's not living in 4 years.
He's unlikely to run for re-election. Kamala Harris had 2% of the vote before she dropped out in the primaries. Now, presumably, she'll pick up some support from her term as VP. But is she really going to be the nominee when she had 2% underlying support? I'm somewhat doubtful. And so I don't know who the Democrats have as a strong challenger in 4 years, like Cuomo or Gavin or Newsom. I don't really know who they have. And the Republicans have some really interesting picks in 4 years. So I think the overall picture for the Republican Party is strong. So even if we're going to lose the presidency, as long as we maintain the Senate, I think we'll be overall okay. Now, that isn't to say that Biden won't be able to do things that we dislike. He will revoke every executive order. He'll probably extend DACA even further. So he'll grant more amnesty to more immigrants. So that'll be an issue there. He'll look to repeal other regulations. The one that I would think he'd be most after in terms of regulation, although it's enforced by regulation, so it's a little bit harder to repeal, would be the one from Department of Education dealing with Title IX cases, would be the one I think that they're going to try to go after. But I think the Trump administration did actually a really good job on it, so they're going to have a little bit of difficulty there. They also, their policy on foreign policy, I think, is going to be weaker. Trump administration managed to keep us out of wars. I'm not necessarily optimistic there. So I think there is some damage to do, but as long as we maintain the Senate, the worst excesses are curtailed. It means that DC won't be admitted as a state. It means that that the filibuster probably will remain intact, although I'm not a fan of that in the first place. Mm-hmm. But the Republicans have majority anyway, so what does it matter? So I think the worst excesses will be curtailed. So it'll be interesting in particular to see who Biden picks for various cabinet picks. I think Department of Homeland Security, Department of Defense, Department of Health and Human Services, Department of the Treasury are probably the four that I'd be looking at, and Attorney General would be the five that I'd be looking at for the biggest indications of where this is going, because those are, the Attorney General will decide on prosecutions for federal offenses and so forth and so on. So those would be the five I'd be looking at. But I think I wouldn't say it's a rosy picture, but I'd say it's not overly bad. It's okay.
At this point,
it'll be okay. It'll be okay.
I want to address one more topic. It'll be okay. We say as we drink in the middle of the daytime, hoping to God we're right.
I'm trying to make projections 4 years out. So, I'd like to think that I have a lot of knowledge, but I'm trying to make projections 4 years out. So I'm making a lot of guesses. So I'm drinking, hoping I'm right. We'll find out, I guess.
The thing I want to bring up, and this is a new thing, and this is going to be hard. I started to talk about this a little bit earlier and we got sidetracked, but there are two blitzes going on. One is the court blitz, which has not been going well. The one that's been going exceptionally well for the Republicans, depending on your perspective, is the media blitz, because they have convinced the base of Republicans. It's something like 79% of Republicans believe that Joe Biden unfairly won the election. They have convinced the base thoroughly that this happened. The problem is, the very big problem with this is, and I saw this in the chat, someone was saying, we'll never win another election again. Yeah. It's within the Democrats' best interest that Republicans specifically believe that their vote is worthless.
Yeah, of course.
And so the idea that they cheated out in the open has been said a lot, but I want to point out that literally no one has brought forth any amount of evidence that shows this. We can get inferences, we can make leaps to, and they're not the biggest leaps, to say that there were issues with the ballots coming in after midnight, there were issues with Dominion software. I'm fine with that. I'm okay accepting the premise that this happened, but I would really, really like some of these people who have all of the proof to actually give any of that. And that's what every single court has been asking for too. Okay, if you're asking us to overturn even a precinct is a big ask, much less an entire state certification. You have to come in with the biggest guns that you've got, and you're talking about widespread fraud, and you're never bringing anything related to widespread fraud other than these nebulous allegations. And that's the hard thing that I think that the Republicans are going to be reeling from over the next couple years, and maybe to our detriment, is that we've got a bunch of people who feel disenfranchised, and they might have been, but the people with the responsibility to show us where haven't done it. And that's a big problem.
No, I think that's completely right. Now, I'd say a couple things. In terms of the 77% number you alluded to, Republicans thinking the election is stolen, there does seem to be fairly good evidence that that number might be soft, and there might be things different about this time. But at least in the past couple times, we've seen this kind of swing where the percentage of people who think the election was fair versus stolen is based on who won. So you can see that in past elections where the numbers are kind of flipped and they go back and forth, back and forth. So if it went the other way around, the Democrats would be probably somewhere in that ballpark of thinking it was stolen, and the Republicans would be somewhere in the ballpark where the Democrats were. The Republicans would think it's fair, the Democrats would think it's unfair in the alternative universe where the numbers were flipped. So there's one thing there. The one thing that concerns me about why this might be different this time is because because Trump is screaming so hard about it, and I'm concerned about the long-term impacts. Now, I kind of think there's a lot good about Republican policy and a lot good about the Republican message. And then the numbers confirm that to me in terms of the House and Senate and the governorships and the state houses, state senates, that kind of thing. So the numbers suggest to me there's a lot that's well accepted about the Republican message. It's just that Donald Trump is a particularly bad vehicle for it. And owning the libs is fun and all, but from a philosophical point or an explanatory point, he's not the best messenger. Someone else with that message would be presumably more successful. So Donald Trump showed us an idea, but he may not be the best carrier of that idea. Someone else who can explain it from first principles is better, because you can defend pretty much all of Trump's policy issues, the things that he did. You can defend them from first principles. He just wasn't very good at doing them, so people didn't understand why he was doing it. But I think it's in the Republican interest that Trump kind of go away. And I think that will happen because Trump will get out of office. I'm pretty convinced that on January the 20th, if not shortly thereafter, he'll be banned from Twitter, banned from Facebook.
I agree.
He may try to start a media company, but they're not going to give him any more daylight. And I think it's actually in the Republican interest. Well, I think it's actually probably in the Democrats' disinterest to try to investigate them or try to bring criminal prosecution, because that just gives him more daylight and lets him play the martyr, and that just riles up his base. So I think the Democrats' best play, I'm not sure they'll do it, but Democrats' best play is probably just to ignore him and let him silk away into the forgotten land. That's
what I said last night. My guest Mark Kern disagreed. He said he thinks that the left will need a punching bag in their victory, and they'll use Trump as a punching bag to try and discourage people going forward. I mean, I don't know which one is true. I can see both sides of it. I tend to land more on the side that you're talking about. If I were the shadow hand or whatever controlling everything, I would remove him. I would remove his ability to monetize, to communicate, and do business effectively, and let him fade into obscurity. I think that's what I think. Mark disagreed, and I respect his opinion. I'm not besmirching it in any way. I just think that's how I would do it. So
yeah, I agree. So I am obviously, who can say what will happen? I think the far left is a bigger influence in the Democratic Party than the far right is in the Republican Party. I think that the more left-leaning socialist Democrats will be looking for power. Now, they appointed John Kerry as a special envoy on the environment. I don't know what the hell that even means. What is a special envoy for the environment?
Look, when you need someone to go and talk, they got to have someone go talk to the trees.
I don't know what that is. Yeah,
exactly. He's got to go hang out with the nymphs and stuff.
Maybe it's an effort to satiate the further left elements and make them go away. but I feel like they're not going to go away, and that they're a threat to the party. So I don't know what's going to happen. Again, I'd point to the cabinet positions. I point as being the most interesting ones. There's been a suggestion that Merrick Garland is going to become the AG. That's the rumor I've been hearing. I don't know why you necessarily step down from being a federal court appellate judge, the chief judge of the D.C. Court of Appeals, which is the most important court of appeals, and it's the most important position in the Court of Appeals. I'm not sure why you step down for AG, but I think the Republicans would approve him, and it would be a lot better than some of the more extreme left picks they have, which would be a real problem for the Republicans. So Merrick Garland for AG, maybe. In terms of the other positions, I don't know. It'll be interesting to see if they appoint someone like Whitmer or someone like Senator Warren.
Michigan can only pray that they put Whitmer in some effectless federal position.
I was thinking HHS.
Oh God, please don't do that to me.
That was what I was thinking. Yeah, I was thinking when I was thinking Whitmer, I'm thinking HHS, because like, hey, who better to run our lives and control our lockdowns and impose on us from on high?
Yeah.
So the disaster cabinet would be someone like Whitmer for HHS, because why not? As long as we're predicting disaster. How about Alexandria Ocasio-Cortez for head of EPA? That might be fun.
Jesus Christ. Stop it. I said we're supposed to have equal levels of doom pills, and now I'm sitting here like weeping in my seat, and you've only named 2.
Yeah. I think, there's a lot of potential problems that are coming down the pipe. Elizabeth Warren would be your doom pick for Treasury, or Bernie Sanders, but I think Elizabeth Warren actually probably better / worse depending on your point of view.
Ilhan Omar as head of DHS.
Yeah, there you go. You're on the right. You're on the right track.
Who's the doomer attorney general? Is it just Kevin Landau? That's you probably don't know who that is. One day I'll introduce you.
No, I was trying to remember his name because it starts with like a V. It's like VJ or something like that. I'm trying to remember what his name was.
What's
I was trying to actually. Well, he's very famous on the Democratic side for like.
Devin Stone. That's for Attorney General.
No. No.
Look, he's the most popular YouTube lawyer ever invented. We've got to get Devin Stone up there to bring the clout to the White House.
Yeah, no, I think we could do without Devin Stone. That'll be just fine.
Oh,
and
God.
I don't need to hear more about how Captain Marvel was assaulted, and it's all Don's fault. That's good.
Okay, let me read through the chats that are in, and then let's go to this hearing. This is going back to the hearing. I did skip a large section of the hearing, one particular argument from the defense counsel, so not the Trump team, but the other team, and it was about abstention. Mm-hmm. And a brief explainer on what abstention is. That is the idea that the federal court, even if it can intervene or can hear a case, should not and should defer it to state court because it's a state court issue ultimately. Sure. So they didn't end up abstaining. So abstention wasn't the end result because they just dismissed the action entirely. But the guy's mic was a potato. I mean, he's literally talking into a russet potato with wires sticking out of it. And I don't understand how attorneys who charge like $900 an hour can't afford a Yeti mic, just for these things that they've been doing. It's like, oh my God. But I skipped it because you can't hear most of what he says, and most of his arguments are just a rehash. But I've got it picked up right after that because there are some good arguments that follow, again reiterating just how weak of a case the Republicans brought. And I want to point this out because I think it's critical for guys like you and me who people know and understand. We are typically conservative. We tend to be on the pro Trump or Republican side of this issue, to be the ones pointing out that our side just quit. Like they just didn't do their jobs for whatever reason. And they probably have some good explanations as to why, but they're not really helpful. So Let me read these chats and then we'll do that. Bad Vibe says, Igor, it's alive. Alive. Okay, very weird. Viden the Colden says, hey, Nick. Hey, Uncivil Law. Hope you are both well. Nick, remember to shill your other channels, you boomer. Yes, I am trying to reach 10,000 subscribers on both my Twitch and my other YouTube channel. Please check them out. Ricada Media on YouTube and Ricada Law.
Can I throw in a movie request?
Yes.
I'd like to do Equilibrium. I think it's on Amazon Prime.
Is it? That's such a weird movie, but I will bring gun kata to the masses if necessary. Everybody Poops says, Rackets and Uncivil Law, when are you going to get your BitChute account when YouTube yeets you off the platform? Also, if we're heading towards a neo-corporatist future, is there any hope? I have a BitChute account. There's nothing on it. But what about that second one? If we're headed towards a neo-corporatist future, is there any hope?
I mean, I think there's always hope. I think that the Trump campaign, and Trump was successful for a lot of reasons, and there's a lot in his message that should be valued. So I think he did a lot. I mean, up until COVID, he was doing really, really good. You know, he brought a lot of trade back to the United States, manufacturing back to the United States, lowered corporate tax rate, which I thought was good. Had good policies on China. He dealt very well with the China issues, especially short term, maybe less on long term, but you know, for short term, did great work in the Mideast with the peace deals. I thought he did well on border security issues. So there's a lot in his message that I think could resonate well with a better speaker, someone who can speak to it from first principles and explain the philosophical underpinnings of the ideas.
Well, and I think, and I don't think you said this, but I think people could infer it. I thought he handled COVID the way I would pretty much want a president to handle COVID. I did not want him to step in and take federal control over things where he had no business doing control, things like federal mask mandates, things like federal shutdowns. He didn't do that. They offered lots of guidance. People can criticize with hindsight some of his decisions, but I didn't even see too much really there to criticize other than maybe shut the border sooner. Of course, that would be ignoring the resistance he got on that. So, I mean, you didn't say that he did bad with COVID, but you said up until COVID, he was doing well. And I think politically, he really was. And I think politically, COVID is one of the biggest culprits in killing the Trump campaign.
I mean, without policy, there's always the bully pulpit. And I think he could have used it to encourage people to wear masks. And I think that would have been helpful on the messaging and he also invoked the Defense Production Act for the purpose of producing ventilators. And he could have also used it for the purpose of producing N95 masks and PPE for hospitals. I think would have been helpful. But I mean, Cuomo did just win an Emmy for his messaging.
His messaging was great,
which makes me want to gag. And although I don't think necessarily that's the right way to go about it, I think he could have done a little bit more in terms of promoting health, in terms of encouraging people to take measures. And I think it was a mistake to. He basically said it was false. He said it was fake. I'm like, yeah, not really completely. I mean,
yeah, I think that messaging, I largely agree with the thrust of what I think he was saying, but I think the way he said it was unfortunate. I think what he should have said is, something like this doesn't justify shutting down a nation and an economy and putting people out of work. However, if local officials want to need to deal with this in specific ways, then they should do that. I think that might have been better messaging than this is a fake crisis or whatever. So I can see it both ways, but it's interesting. I don't know. We can always look back and criticize, though. That's an easier thing to do. And we've got a challenging question coming up about looking back and criticizing. Cac7Go says, this mofo here is so classy. He's drinking wine and laughing at plebs who don't understand the law. Look at what a real lawyer is, Nikki, and try to aim for that. Thank you, Cac. Oh, hi, it's Will. Says, wait, isn't releasing the Kraken something bad guys do in movies? I mean, only if you watch what was it? It wasn't Jason the Argonauts. Clash of the Titans. Only if you watch Clash of the Titans. Releasing the Kraken was bad. And I'm curious as to who Perseus will be in this one. Nova Zero says, if Biden lets up on China and doesn't get the hardest of backlashes, your allies won't be happy. It's stayed bipartisan, but the stuff Biden said on China has been absolutely insane, given what's happened in Hong Kong and Taiwan. Oh, yeah, I wouldn't look for Biden to be your shining rose on proper Chinese action. I don't think he's going to do well on foreign policy generally at all. I think we're going to go back, basically, we're going to go back 6 years on foreign policy. That's what's going to happen. And it'll be fun having all the wars again. Mm-hmm. Super Iron Bob says, with respect to COVID, it's important to consider timelines when things were said. There was a lot of shifting rapidly and a lot of unknowns and a lot of false reporting. Uncivil is collapsing things inappropriately here.
That's fair. I mean, what I said was necessarily reductionist. So that's a fair point.
Yeah, and also, again, we're talking with the benefits of hindsight as to things that might have changed the narrative or changed the reaction. Not that those necessarily would have been easy to do at the time. It's just talking now into the past. Okay, I want to do this one specifically, even though it's not one of the big ones. But Frank the Tank 285 asks us, hypothetically, what would we have done if we were the Trump lawyers? How would we have run the case?
I mean, I mean, there's only so much lawyers can do. And at least from my point, I'm not saying I'm the smartest lawyer, so I'm willing to admit that maybe I have limits, but I can't see any path forward. I don't really see anything. I'm sorry.
The hardest thing for that question for us is we're in the same boat that you guys are, in that presumably, according to the people piloting the ship, there's a bunch of stuff that none of us have seen. Okay, so if I take Sidney Powell, Lynn Wood, heck, Rudy Giuliani at their word, and I have access to all the stuff they've said they have access to, the main thing I do differently than now is in every petition, all of that stuff is front and center and repeated over and over throughout the petition. On every cause of action, you say, when relevant to the jurisdiction, you hit and you say, look, we can show that there are 630,000 votes that need to be overturned. Here's the votes. Here's the votes. Here's the votes. So we have a cause of action in this county. We have a cause of action in this county. We have a cause of action in this county because we had this result here that's impacted by 160,000 votes. This result here, which is 200,000 votes. They haven't put that in a single flipping petition, and it drives me crazy that Rudy will stand up at oral argument in Pennsylvania and talk about all these votes without putting it into the case itself. So, assuming that silver bullet exists, that they keep talking about and have been literally from day 2, they've talked about having this information. We're now, I think, 15 days out from that, and it's never once been presented to the court. The only time they've talked about evidence, and this is true, it is evidence to say that they have a bunch of affidavits, but that's all they've ever produced are a couple affidavits. Now, Rudy said they have hundreds to even 1,000 affidavits, and they've produced something like 8. And the affidavits that they started to put forward in Arizona were shut down because of all the affidavits they had to withdraw, because the affidavits that they had, they verified as false. And the judge called him out on that in Arizona. He said, wait a minute. You've just left in the affidavits that you couldn't prove are false. You're not even asserting that these affidavits are true. You're just asserting that they're not false as far as you can tell. And they got tossed out of court because of that, and because of the overwhelming amount of affidavits that they wanted to present and actually held back from the court. And they told the court, we had this many affidavits that were actually provably, verifiably false. Now, in the talking point narratives that are out there from Rudy Giuliani, he doesn't mention that a large amount of those 1,000 affidavits, they won't even bring to court because they're verifiably bad. So what would I have done It really depends on what information actually exists. But you have to also consider that their strategy is merely to put forth plausible enough cases to create enough of a message to try and energize Republican legislatures to overturn the vote. And if they don't have the actual information, that's their best gambit, and it's the longest shot on earth. That's my opinion. I don't know. So that's the answer to that one. And
yeah, if there's actually super secret evidence, that would be really helpful. Yeah.
It really needs to have come out yesterday, but today would be fine. Tomorrow will be acceptable too. But after that, you're out. You're out of time. They have to go through district court, an appellate court, and then maybe the Supreme Court in 2 weeks.
Yep.
They're out of time, guys. They're out of time. They have to have an emergency motion on everything from this point on, with 1 day briefing schedules at every step of the way.
Yep.
And they're, Versi says, do you think the Biden admin can implement anything that we could never reverse in the future? Also, what has Trump done? Do you think that will be near impossible for the Democrats to change if Biden takes over? Also, hello. Hey, what's going on, man? Do you think everything can theoretically be undone, even though some things have proved sticky, like DACA, for example, done by executive order, harder to reverse. Although Trump has basically just ignored the court on that, so maybe it's reversed in practice, but it'll be re-implemented under Biden. I don't know if Trump's done anything that'll be really difficult. I mean, any legal stuff is going to be difficult so long as Republicans maintain the Senate. You're going to have bipartisan support for bills. I guess that's the best answer I can give. Any addition to that before we do this thing?
No, let's do some oral argument.
All right, here we go. Oral arguments are starting now.
Donovan, you signaled that two of the counsel representing the intervenors wish to make some commentary to the court.
Yeah, Judge, one amendment for Center County Counsel has about 2 minutes. She'd like to address an issue if she could before we go to the intervenors.
That's fine. So Ms. Dupuy or Ms. Beach, Ms. Dupuy?
Your Honor, thank you. Elizabeth Dupuy for Center County Government. Center County joins in the standing and abstention arguments stated previously, but additionally, based upon the allegations both in the amended complaint and the proffer of evidence in the plaintiff's opening argument, Center County did nothing wrong. The plaintiffs do not put forth any concrete facts.
Just like Hitler, I guess. Why would you say that in court? That's terrible.
That's the best phrasing, yeah.
By the way, if you want me to pause at any time, just let me know if you have a comment to add.
Facts in the complaint which show a violation of law as to Center County. We know from the PA Supreme Court decision that the manner of handling pre-canvass is a county decision. Looking at the complaint as to Center County, handling of the pre-canvass, which the plaintiffs correctly note was in a ballroom, which was live streamed on the web, and more importantly, all candidates and parties had full access to the room during the 2-day period. Additionally, no complaints were made by either party or campaign to Center County. The other matter in the complaint is an unspecific allegation that a voter, not identifying the voter or the precinct, we have 80+ precincts in Center County, received a provisional ballot. If the same were true, per the election code, the challenge to that ballot should be handled through the provisional ballot process, which is under the Pennsylvania election code. Again, the issue of abstention. The plaintiff campaign team was present the entire time that Center County reviewed provisional ballots and raised no objections to the process, nor were any provisional ballots in Center County challenged. Center County is entitled to a dismissal of this complaint against it based upon both standing and abstention and the failure to state a claim.
Thank you, Mr.
Okay, so real quick, her argument was very short, and it goes to the failures of picking parties in this case. Again, the two individual plaintiffs that were brought, their counties where their votes were taken away, which is going to be covered in the next guy's oral argument again. when those votes were taken away, are not parties to this case. Lancaster and Fayette County, I think. They were not included as defendants in the case, even though that is where their votes were disenfranchised. Instead, they had, this county, which was Center County, I think she said, and they had even the allegations of not being able to observe the ballot process fail in that county, because she said the campaigns team was literally in the room with them. They're there, and at the time, they never raised a single objection.
Yeah, that's the thing that caught my attention, where they never raised an objection. It's what we were saying, at the start of the stream. You use it or you lose it. If you don't bring things up, you can't bring them up later. So if someone had the opportunity to object and they didn't, it's gone. So that's what caught my attention. I'm like, yep, that's it. End of the game there.
And so for all of this, again, I have to bring it back to, for all of the talk about fraud, when they had the opportunity to call out fraud within the process, they didn't do it. Presumably, and the only presumption you can take from this is that they didn't witness fraud, at least in regards to Center County. So then why are they bringing up Center County as a target in this lawsuit? I think it's probably because it's close to Philadelphia or Pittsburgh. Do you know where it is in Pennsylvania? I have no idea.
No, off the top of my head, no.
But I'm guessing it's one of the big counties. And the problem is they don't have any injury particular to that county. And when you start adding in counties and making it look like you're trying for a political outcome through the court, it undermines your argument.
Yeah.
Okay, next guy. I like that it sounds like a hairdryer is running constantly on this thing.
This is one of the things I really hate from the new oral arguments. Same problem with the Supreme Court, where the audio sucks.
You have all the money on earth.
Remind me, sir, who you represent.
Buy a mic.
Zoman Quanto on behalf of the DNC, Your Honor.
Okay, yes, thank you.
I turned him down just a hair. Oh my God.
Good afternoon, Your Honor. I'm here to make a few quick points about some of the arguments that have been raised that I believe are dispositive to this claim, to the case that have been brought by plaintiffs, and I will make every effort not to repeat arguments that have been made already. First, I want to start off with the injury that plaintiffs have alleged. Plaintiffs have actually disclaimed any vote dilution injury on page 4 of plaintiffs' opposition to defendants' motion to dismiss. It states, yet plaintiffs' injuries do not turn on vote dilution, but rather vote denial. That is in the beginning of the second paragraph of page 4. And the
really briefly, we talked about this yesterday. They removed their vote dilution claims because they got hammered on it in Georgia and every other jurisdiction that they tried.
It's a non-starter. You don't have specific injury.
Right.
Your injury is the same as everyone else. It's a total non-starter.
Yep. And so without that vote dilution, there's no claim there. So they stuck with vote denial, and he's about to address the problems with sticking with vote denial in this particular context.
The reason that is instructive here and the reason that is dispositive here is because a vote denial injury is not traceable to any defendant in this case. The plaintiffs in this case are from counties that are not listed as defendants here. Lancaster and Fayette County are the appropriate defendants in a vote denial claim. A vote denial claim alleges that some party improperly or unconstitutionally denied an individual the right to vote. None of the defendants in this case have done that. And when it comes to the Trump campaign, as Mr. Donovan has spelled out in detail, the Bognet case makes clear that individuals, whether individual candidates or campaigns, do not have standing or a right to enforce the general code and enforce the election code generally. These individuals have to demonstrate that the procedures that they seek to challenge and the potential election law violations will actually affect the outcome of the election. And the Trump campaign has not even made any such allegation that has occurred. Next up.
Sorry, someone on the stream yesterday asked, please tell me there's a disparate treatment argument in the complaint. As you can tell from what this guy just said, there is not a disparate treatment argument in the complaint. What we have is them complaining that the election law was enforced or not enforced in particular ways, but they have not shown that that disproportionately affected either party positively or negatively. And not only have they not shown it, they didn't even argue it. So
That sounds like a problem.
it's an oversight for sure.
Yeah, well, oversight's one way to put it. Totally fatal to the case is another way to put it.
Right. This would be like going into your work. Where disparate treatment comes up a lot is in employment discrimination. So it's like going into your workplace and saying they're enforcing company policies. And then this other department isn't enforcing company policies in the same way. And they go, okay, well, how does that affect you or anyone else? And you said, well, it doesn't. That's what happened. I mean, it's in any case, if there is a proper claim on the enforcement or lack of enforcement of state law, it's state court. It is not federal court. This is the standing argument and why they're getting pounded. And if you guys remember, when they filed this thing in federal court, I said they probably should be bringing this in state court. And there's a reason I said it. It's because they had just gotten thrown out of federal court in a different jurisdiction for the same reason.
You know, the federal courts are very loath to get involved in election matters in this context because the Constitution gives the power to the state. And so you need to go to state court if you're going to go anywhere. But what I was thinking of, that argument reminded me of, I don't even know who it was. Was it the White House press secretary, or was it Sidney Powell or someone who said that the certification of the Michigan vote was merely a procedural step? And then I thought to myself, you know what else is a procedural step? Biden being sworn into office.
It is.
So it's like, it's just a procedural step. I'm like, yeah, but you know, it's kind of consequential. And what that said just reminded me of that.
Right. And that also undermines all of their urgency and haste in these cases to get in before certification and to enjoin it. Well, if it's just a procedural step, that can be easily overturned because it's merely a pro forma arrangement, then they wouldn't have the urgency that they had in this case and other cases to get in ahead of the certification. They're really, really concerned, though they won't say it, that once a state or a county canvassing board certifies election results, that there isn't a way to overturn them. I know people say it's the court can do this, but the court might not be able to decertify presidential election results. Very different from Senate, House, local results. Those are all different questions. Presidential results are tougher.
One of the things that slightly confuses me, and maybe it's just a misapprehension of what different branches can do, and maybe it's just a problem there, but some of the things that people are asking for the courts to do, it's like, do you really, really want courts to be able to do that? Because you have to remember that everything swings both ways, right? What's good for the goose is good for the gander. It's like, do you really, really want courts to be able to start issuing opinions of decertifying votes and all the rest of it? Because because we work on a common law system, we work on precedent. You know, there's nothing really that happens in isolation. Courts learn from each other. Things that happen in the past matter. So if it can be done now to favor Trump, there will come a day in the not too distant future where a court will do the other thing in reverse. Now, particularly from a conservative legal perspective, I worry about this quite a lot. So, and also because I separate legal and political. And I think people aren't really thinking through the long-term implications of some of the things they're looking for. It's like, this court should prevent certification. This court should strike down a precinct. This court should strike down a county. I'm like, okay, if we do that, then what's next? And how does that end? And some of the cases that we cite in our common law system go back before the Republic.
Right.
I can cite cases back from Westminster. Sometimes I'll cite cases back from the Roman Republic because things go that far back. You know, you can't just say it's one time only. And it's like, I think people need to really think through the implications of what they're asking for sometimes, because I'm like, the court should be able to step in and stop this. I'm like, are you sure? Have you thought that all the way through?
Yeah, well, I was having a discussion online with a follower, and so I don't mean to frame this negatively because I think it was a good discussion to have, but his argument was that the Supreme Court will step in and do something. And I said,
yeah,
the Supreme Court really can't do anything based on what they brought. And he said that the Supreme Court should delay the election or delay the results until we can verify it. And I said, well, that would be unconstitutional. That would be asking the courts to go against the Constitution, which they can't do. And we don't want them to do that. That's the whole point of a constitution. And the hardest part of that is that there may be outcomes that we don't like. And his argument was the founders couldn't have predicted Dominion. And I said, well, the founders couldn't predict
I think they
AR-15.
could have predicted Dominion, to be quite honest.
I think so too.
The founders had their own equivalent of Dominion. Dominion as a fundamental concept, the fundamental concept is election fraud. I think they could have figured that one out. The idea of stuffing ballots and all the rest of it. I don't
literally
really think
did
the idea, yeah, they literally did. So I don't think a lot of these things were beyond this concept of the founders. People cheating in elections, people cheating in absentee and mail-in ballots. I assume they had that in the 18th century, some sort of mail-in absentee ballots. I mean, I'm assuming that's not a fundamentally new concept. I'm assuming they had it in the 16th century, probably in some places.
I mean, you'd have to imagine there was some way for people to vote when travel, especially of the rich, important people who voted, took weeks.
Yeah, exactly.
And so
you're telling me some nobleman couldn't vote in the 16th century by absentee ballot by naming a proxy or something? Okay, if you want to tell me that, that's fine. But it's like, everything has precedent somewhere. A lot of these concepts run pretty deep. Modern law is just extension of ancient principles anyway. Modern First Amendment law is like that. Modern Second Amendment law should be like that. It's like we're just extending what was old before to what's new now. It's the same concepts.
And that was my statement to the guy was, well, the founders didn't predict AR-15s.
Well, they didn't predict Facebook either. So how's that going?
But it's like we don't like the argument that the founders couldn't predict AR-15s because that's ridiculous. They could predict repeating rifles. They had them. They had repeating rifles at the time. So certainly that this is just it's just a progression of what already exists. They of course could predict it. So yes, Dominion I think was predictable in scope of stuffing ballots, just doing it in a more efficient way was something that they would understand entirely. But no, we don't. We really have to be careful when saying we want a judicial holdup to political processes, because at some point we won't have precedents for a year to 2 years of legal challenges. If you could just get the judiciary to intervene, and
I feel like people are asking for philosopher kings at this point from the judiciary. Let's just appoint a bunch of philosopher kings to tell us the right answer. I think that's kind of a bad plan.
Yeah,
maybe the legal branches should stick to their lane. That might be good. Let's listen to some more crap from some of these people.
No, Zero says, look, in fairness, God Emperor Trump would force me to take back everything negative that I've ever said about the U.S., complete with Trump vaccine gene seed. Nick, you want this. Kurt, I think we can bring you around. All right, let's go back to the arguments.
I'd like to point to the equal protection arguments that have been asserted by plaintiffs and the claims and allegations in their amended complaint, only to highlight that the main source of their authority, Bush v. Gore, actually counsels against the rule that they seek here. In Bush v. Gore, the court never recognized or endorsed the rule that every single locality has to provide uniform voting procedures. Quite the opposite. In fact, it's unclear what jurisdiction's election code would survive under such a rule, and it would lead to a breathtaking expansion of the equal protections clause. And I want to quote from Bush v. Gore just to make sure everyone in the court is aware of what was at stake. The court said, The question before the court is not whether local entities and the exercise of their expertise may develop different systems for implementing elections. That was not the question before the court. Rather, the state court had implemented a procedure and had the authority to implement uniform procedures, but failed to do so. And that was the issue that the Supreme Court confronted in Bush v. Gore. Now, the Supreme Court also made clear that an overly rigid application of the Equal Protection Clause undermines the state legislature's decision to delegate to local authorities. So Pennsylvania law does not have a supreme election judge that tells every single county exactly how to run elections and whose decisions are binding on every single county. Rather, Pennsylvania law delegates that decisions such that elections are run by county boards, and county boards have the power to make and issue regulations, instructions not inconsistent with the law as they may deem necessary for the guidance of election officers and electors. That's in 2642F. That type
Someone
of
killed a
delegation
robot.
is contemplated not only by Pennsylvania law, but was contemplated by all 9 justices in Bush v. Gore. And there has not been a single case yet that has suggested that such differences in administration of election procedures can somehow trigger an equal protection violation. Lastly, I want to address briefly some of the allegations of voter fraud that have been asserted in this courtroom, but were not included in the complaint. And specifically with respect to Mr. Giuliani's accusations on behalf of the Trump campaign. Because as the court may know, the Trump campaign is a plaintiff, or at least a petitioner, in several lawsuits in state court challenging decisions of county boards during the canvassing process. And in some of those appeals, the attorneys for the Trump campaign were specifically asked whether they were asserting that the ballots that were being accepted were cast fraudulently, or whether they had any information to suggest that there was fraud in the election. So, for instance, in the Montgomery County appeal, there was
Just shoot him already. Just
hearing on
kill
November
the
10th,
argument.
and in that hearing, asked counsel for the Trump campaign whether they were alleging that fraud had occurred. In response, counsel stated, accusing people of fraud is a pretty big step. And later stated, everybody is coming to this with good faith. The DNC is coming to this with good faith. Again, the court asked, are you claiming that there is fraud in connection with the 592 disputed ballots? Counsel for the Trump campaign stated, to my knowledge at present, no.
Okay, stop.
That was
stop,
on page
pause.
11
Stop,
of the...
pause. Okay.
Yep.
Okay. All right. All right. This is the difference between PR rhetoric and rhetoric in courts. Again, I want to go back to an earlier point. Lawyers have a duty of candor to the court. We can't lie to the court. We can emphasize good facts and diminish bad facts. We can emphasize good law, diminish bad law. We can assert rights. We can fight, but we can't lie. And this is the kind of thing where this is manifest. The Giuliani campaign, being good lawyers and following good rules of ethics, candor to the court, they were asked about fraud. They tried to dodge the question. Okay, fair. They tried to dodge the question. The court came back. So how about the fraud then? And
Yeah.
like, okay, not so much with the fraud. We tried to dodge. You picked up on our dodge. We can't evade. And I was like, that's the right answer for a lawyer. I think you can't do any better than that. You fight the court any more than that, it's not going to end well. And they said, well, we're not alleging fraud. I'm like, great. Okay, is it time for tea break yet?
Yeah, and they're honestly lucky that the moment they said no to the allegation of fraud, that the judge didn't just say dismiss, get out. Like, because he could. Like, that's what you've claimed, and now you're here telling us that no, you don't have information that there's fraud. You're not willing to put your word before the court. You're not willing to make a representation under oath that there is fraud happening and that is your claim. And if you're not willing to do that, get out of the courtroom. Stop wasting everyone's time. That they're getting That they're getting consideration at all with the claims that they're bringing is indicative of the sensitive nature of the claims more than the quality of the arguments, in my opinion.
Yeah, I mean, I think the courts have an interest in trying to ensure that fair process was had, and they're interested in trying to see what's there. But when nothing is there, they get a little bit irked. And we saw some irk in the opinion from the Middle District of Pennsylvania, which at some point in the near future I'll have to cover on my channel because it was just so much ownage. We're covering the oral argument now. At some point on my channel, we have to cover the actual opinion because the court took them to task and beat them to death, and they kind of earned it, to be fair.
It was nasty.
Yeah, it was nasty. And, you know, it's like these are the reasons that the court was beating them to death, because they deserved it. They're not able to make the claims that would back up. They're not able to produce anything. They say, well, we don't have any. We're not alleging fraud. Who talks about fraud? And then suddenly they're going to Third Circuit Court of Appeals and saying, well, the court below really fucked up by not giving us a second amended to argue about the fraud, even though we're not alleging fraud. Like, how do you think that's going to end? This is all stupid.
Yeah, their hope
can it end now, please? Can it end now? I know this is completely off topic, but yeah. I just need to say this. Tim Pool needs to get himself a lawyer friend. He just needs to get himself a lawyer friend. I was watching his video with the Quarterly yesterday, and I love the Quarterly. I like Tim Pool. They're fine, but they don't know how to law. They really need to stop trying to law. They need a lawyer friend who can explain this to them, because they're like, well, it says anything necessary, or I can interpret that any way I'm like, no. Why don't you get a lawyer friend to help explain this to you, Tim? That you wouldn't spread misinformation. I love you, man. I'm glad you're out there expressing your freedom of speech, but maybe get a lawyer friend who can help. All right, I'm done with the Tim Pool rant. That's fine.
Tim, I've had Tim on the show. He's a nice guy. You should get him on your show too.
No, I don't mind Tim Pool. I don't mind him expressing his opinion. I believe in freedom of speech. I also believe in my freedom of speech to criticize his freedom of speech and say he needs a lawyer friend.
He does. I can't remember what it was. The other day I was watching something and I was like, please stop. Please, I'll help you. Please.
Yeah, really.
Ryan Mercado says, so they lose on purpose so they can appeal it to SCOTUS. How does that make any sense? Unless they have a very good reason to. Courts are very hesitant to toss out elections because that would disenfranchise voters. Yep, nailed it. Nothing to say there. Yeah, Keck7Go says, can we make Uncivil Law a permanent part of the show? Because he clearly cares about the show and your community more than you do. He's even in the damn Discord channel for your patrons watching the show live. Also, woke is good. Hey, stop showing me up. Oh, my goodness.
I may also be in the Discord communicating with that chat at the same time, yes.
All right, here, back to these.
Also, while I'm drinking wine and also listening to oral argument and also listening to you at the same time. Wow.
That's too much multitasking for me. I'm staring at the audio levels going back and forth.
Nice.
Very important job. All right, here we go.
Montgomery County transcript. I know that transcript is not before the court, is not in the record, but nor were the allegations asserted by Mr. Giuliani. The DNC is happy to provide that transcript, but to the extent that those allegations do come before the court, or the court decides to consider them, the court should also consider these statements made by the Trump campaign's attorneys before state courts. I'd like to also highlight a hearing before the Philadelphia Court of Common Pleas. And I believe Ms. Kern participated in this hearing. And in that hearing, the court asked similarly whether Ms. Kern was alleging voter fraud with respect to the challenge ballots. And Ms. Kern answered, I am not proceeding on those allegations. She repeatedly, throughout the transcript, made clear that she was not asserting any claims of voter fraud. So the allegations that you have heard today, that is not the position that the Trump campaign has taken in state court. And if there were anything that confirms this, I will point to, and this is actually on the record, the order issued by the Montgomery County Court of Common Pleas. It was actually filed as an exhibit to one of the interveners' briefs, and the docket number is 142-1, page 3. And it's, I think, halfway down the page. And I'll read this excerpt.
Oh, God.
It states, the court heard oral argument on November 10th, 2020.
Yeah.
Petitioners.
Here we go.
I was just saying, please don't, please stop.
Oh, I thought you were telling me to stop.
I'm not telling you to stop. I was telling him to stop. I'm sorry. That's a little clear.
I want to say something, though, just on the nature of how the arguments are presented. I mentioned this yesterday. I want to reiterate today. Rudy Giuliani brought a lot of narrative. These guys have brought nothing but citation and quotation over and over and over. They're hammering the Trump team into the dirt right now. Now,
I will give Giuliani a bit of credit here because I think narrative is extremely important. I actually personally do believe in storytelling because I think that people follow story and they don't follow as much fact and analytic. And I think a well-told story arc, I think you can just follow the rules of screenwriting, to be quite honest, in terms of how a legal complaint or in terms of how a trial should be structured. You want to tell a story, you want to tell arcs, you want to hit the same kind of themes. I think it's very similar. So I think the Giuliani campaign had a nice idea. The problem with Giuliani's idea is that he doesn't have anything backing the story at the end. And the analytics are just overpowering the story. But I think that the structural idea made sense. So I don't criticize Giuliani for the way that they structure the argument or structure the narrative, because I think narrative wins the day at the end. I just think there was nothing behind it, and that's the problem. It's a shallow narrative.
The other problem I'm going to assert with it is that it was incongruent with the filing.
Exactly that too. It's like you can't make arguments that are inconsistent, and they're making arguments to the Third Circuit that are inconsistent. It's like what exactly are you even trying to argue? When you're trying to confuse the court, it's not helpful.
Right. Okay, back to this. I might skip this guy because he's getting annoying.
So I was telling him to stop because the pain was too real.
Maybe we should.
Like I'm almost done with my wine. I've only got about an eighth of a bottle left. It's very sad.
Maybe I should skip up to Rudy's where Rudy comes back. Should we do that? Yeah. Okay,
I'm going to do what makes sense to you.
I'm going to do that because I think this is
being the Trump campaign went now. These are statewide races.
In the Third Circuit, latches can be applied at the motion. Take 2 shots.
Who do we have next?
Areas beforehand.
Okay, we're back to Rudy G.
The conduct was egregious. The conduct was premeditated. The conduct was planned. They have to have gotten those barriers beforehand. They couldn't have just done it on the spur.
Okay, so he's talking about, again, something that's not actually in the case, which are these kennels that they allegedly put Republican poll observers in several different Democrat-controlled cities. I say allegedly only because they have not properly pled the proof before the court. But I'll take him at his word. I believe that this happened. Absolutely. Because of COVID, I'm willing to accept that this is going on. So
for the moment. And the purpose was to have those ballots examined in secret so that only a Democratic office holder would get to see it in just 2 counties and no place else in the state. I heard the representative of Chester County, I believe it was, or was it Delaware, I'm not sure, say that didn't happen in their county. If that's the case, we would consider dropping that county from the lawsuit. But the reality is that we're not asking for the entire vote to be canceled. We're asking that the remedy be the remedy that is usually applied when there's a violation of the rules with regard to absentee ballots. And this is an egregious violation, a planned violation.
Except in the document, they literally asked for the entire vote to be canceled. That's their number one remedy to the court.
Yeah, well, strictly speaking, they asked for the certification to stop.
True.
And Viva Fry had a criticism here because he thought it was straw man, and I disagree with him because what the court ultimately said is you're asking us to disenfranchise votes, and Viva Fry said, well, that's a straw man. What they're asking for is to prevent certification. To me, I disagree. I think that's equivalent, And I think that's a fair way to characterize it. If you're asking to prevent certification, you're asking to prevent the democratic process from going forward. And that's ultimately preventing votes from being counted. So I think the court is on the point, personally.
Yeah. And they specifically asked for all of the statewide decertification as their first remedy. And then I think localized decertification as an alternative remedy. So, but anyway, let's keep going.
The remedy is really required and is draconian because their conduct was egregious. Who ever heard of 600,000, 700,000 absentee ballots not being examined? It's never happened in American history. So the scope of the remedy is because of the scope of the injury. We're not asking that the entire election be reversed, but these ballots were not examined. And that is not just a state issue, that's a due process issue. We would contend that one of the fundamental tenets of a fair election in the United States is the ability to inspect, particularly mail-in ballots, which are seen as inherently difficult, fraudulent. You can go to all the authorities. We've been afraid of that for 20 years. Now we have it, and the only way we can police these ballots, there's only one way. That's the inspection. If you're going to make a mockery of the inspection, I don't know where we're going to go. I mean, as far as we're concerned, Your Honor, those ballots could have been for Mickey Mouse. We have no idea.
God.
Have no idea.
Yes,
I think we'd have some idea if they were for Mickey Mouse because they would have been counted Mickey Mouse.
I think he's about to say.
I think I know what he was saying, but I don't want to give him credit.
No, he said from Mickey Mouse, not for Mickey Mouse.
I apologize.
And I think, if I'm not mistaken, it was either in this oral argument or at a press conference. He says, which did happen.
Okay.
Yet, okay, take a picture of the ballot and put it in front of the court, I guess. But the answer isn't to decertify the entire election, because how did Mickey Mouse vote? But anyway, we'll keep going.
This has never happened before. And it didn't happen. And the reason I pointed out that it happened in other states, for which I was personally criticized, is because there was a connection here. There's a connection between Philadelphia and Pittsburgh. And then exactly the same thing happened in Detroit, and at the same time, and exactly the same thing in Milwaukee, and exactly the same thing in Nevada. Republicans were uniformly refused the almost obvious right to inspect an absentee ballot. I've never heard of that before, that an absentee ballot wasn't examined, and it was done for a specific purpose. If that ballot were a perfectly fine ballot, Your Honor, why wouldn't they have invited the 18 Republican inspectors that were there, or 20 or 30 that they were keeping in a pen? Hey, take a look at it. It's a real good ballot. And then if you look at where they were and where they came, they started the process at 800,000 votes, 700,000 votes behind. And they caught up in counting a lot of those ballots very furiously. Some of our witnesses will say,
okay, stop. I was waiting to see if it would develop somewhere, but it didn't develop anywhere. And I have to go back. I know it's 30 seconds back in the past, but I was waiting to see if it went anywhere. So he's basically alleging that Philadelphia and Pittsburgh, which are in Pennsylvania, and Detroit, which is in Michigan, and Nevada, all essentially conspired to uniformly deprive people of the right to be able to inspect votes or something.
Not only is
he's saying that these people, he's saying that Pittsburgh, Philadelphia and Pennsylvania, Detroit, Nevada got on a phone call and it's like, how about depriving Trump supporters of their ability to count ballots? Ha 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 ha.
Not only is he saying that, earlier in his opening oral argument, he does say you'd have to be a fool to believe it didn't happen.
Uh-huh. Okay.
But he doesn't allege when said communication took place or how or by whom.
When did this theoretical communication took place? On election day, purportedly, when they decided to stop counting votes or something, they got on a massive phone call, or maybe they had an email, or maybe they have a Discord. That'd be good. Election voters of the United States certification Discord. Is there a Discord out there for these people run by the Biden campaign or something where they're in an admin chat about how we should deprive the people of their ability to watch votes? So they're all communicating collectively.
I'm hearing there's evidence of Zoom calls in which this happened. Now again, I'm even willing to take that arguendo.
Is there a witness to the Zoom call?
Where's the Zoom call? Like
Did someone observe this? Is there an insider who said yes? That would be helpful. How about someone who's an insider? Yes, I work for the Secretary of State's office of insert, and I observed on the Zoom call these following people communicating about the dark scheme. Do they have that? That'd be really great.
It's not in the case, guys. It's not in the case. This is the problem. Again, if it exists, it's not in the case. Don't be mad at us for them not filing it.
At the envelope. Just throw it in a bin, throw it in a bin, throw it in a bin, throw it in a bin. And I also take exception to their saying we didn't plead it and that I didn't plead it. My goodness, Judge, I was accused of not reading your opinion.
But you didn't plead it. Sorry.
And if I did, not understanding it. I have read your opinion, and I do understand it, and it's completely distinguishable from this case. You were dealing with pre-election, and you were dealing with what could arguably be considered an injury that may or may not happen, a generalized grievance. We're not dealing with that. The election's over. Those two men just lost their right to vote. They lost their right to vote because they were treated differently in their counties than they would have been treated if they were in Philadelphia or if they were in Pittsburgh, where in fact the secretary varied the law. The law is clear. You can't cure a ballot. It's clear. The legislature hasn't changed that.
It's not clear, damn you.
The secretary has no legislative power.
It's ambiguous.
That was it. And then they say that those two plaintiffs, our clients, should sue their counties. For what? For following the law?
Wait, what is your argument then? Hold on, sorry, I stopped it prematurely.
And not violating the law? Like their counties? Why? I mean, if I were in that county, I looked at the law, and the law says you can't cure a ballot. But then the secretary says, oh, it's okay to cure a ballot. As a good lawyer, I'd say to my client, secretary doesn't mean anything. She can't or he can't vary the law. The law is set by the legislature. And this isn't some technical law like, is it 3 days or 4 days? It's can you
Why is that technical?
That is invalid. That's a substantive law. And I would tell my client, don't do it. So I don't know what we would accomplish by suing those two counties. They didn't do anything wrong. The county.
No, my head hurts. My head hurts too much. Why is 3 days versus 4 days a technical law? Because the best legal argument I've seen so far is the ballots received after Election Day were invalid. So he just said, oh, the difference between 3 days and 4 days, it's technical. So presumably the difference between receiving them on Election Day or after Election Day is equally technical because it's only a difference of a day. But that's the best legal argument I've seen. He just completely undermined the best legal argument that exists by saying, oh, the difference between 3 days and 4 days is technical. Why is that not substantive? Holy shit. Why am I better than Rudy Giuliani? I shouldn't be smarter than him, especially as much wine as I had. This is annoying.
Well, and the other frustrating part is, again, that I agree is their best argument. The fact that the House or the federal legislature has set and established a day for the choosing of electors, and that any extension beyond that day, specifically or explicitly beyond midnight local time, would be the extent of it. That any extension beyond midnight local time in any jurisdiction would be too late. That any ballot that came in after that time, that is their hands down best legal argument, and I haven't seen it in a single damn case, and I can't figure it out.
But it's just technical, Nick. It's just technical. It's just 3 days, 4 days, Election Day, after Election Day. What the fuck does it matter? Holy shit. Let's listen to some more bullshit. This is good.
Something wrong are the counties that varied the law to make it easier to accumulate enormous numbers of illegal votes. Now,
He doesn't ever say how many votes. He just says it's a lot. They haven't, again, this is another problem. They have yet to allege even a ballpark amount of votes that this applies to. How many votes were allowed to be cured? They haven't said. Now, he said they don't know, and that, maybe they don't know, but I'm sorry, not knowing is fatal to your case in just about every instance.
I'm having a hard time believing it was a lot. I mean, these would be ballots that had some sort of defect. Signature was invalid, address was invalid, something along those lines. And they contacted the voter to fix whatever it is, present ID, fix your signature, provide the address, whatever the technical deficiencies are. But how many ballots could we even theoretically be talking about? I mean,
the most
1,000,
I can
5,000, 10,000, lest I forget to mention, right now the difference is 80,000 votes. So do you think that there's enough problems to fix an 80,000 gap? It's insane.
And
there's not 80,000 votes out there. I'm sorry to keep interrupting you, Nick. I just can't believe it. Yeah.
Well, we'd also have to presume that every remediable vote was only for Biden. In this case, for these votes, where we say that someone just screwed up on sending in their ballots and they got notice. What they haven't even established is that only Democrats got a notice to cure. They haven't even alleged that only one party got a notice. That might be enough. If they could constructively show that only one party got a notice to cure and no other party, like no Republicans got a notice to cure, they could maybe show disparate treatment. But they haven't even alleged it, and they can't because they just don't have the info that Rudy is saying. They can't back up their own statements, and this is the big problems with this.
They say, well, we don't know how people voted. We do know that in Philadelphia, the vote was 8 out of every 10 for Biden. So let's not be stupid. I mean, that's ridiculous to say we don't know what would happen.
You really don't, though. You still don't. You can only infer that it'd be an 8-2 split.
And if it was equal over the entire state, why don't they do it all over the state? But the reality is this was a deliberate plan to do this. And to say that we didn't allege these voter violations of the inspectors, Your Honor, from page 56, in every instance where an absentee mail-in ballot is opened and canvassed, poll watchers are supposed to be present. Defendants have not allowed watchers and representatives to be present when the required declarations are containing official, when the ballot envelopes are open and when such ballots are counted and recorded. Isn't that what I said? It's in the complaint. I wasn't making up the complaint, and I feel aggrieved by their misrepresenting what I said. I mean, to say that it's not in the complaint is just plain wrong.
I'm sorry. If someone outright misrepresents what you say in your complaint at oral argument, you're not aggrieved. That's just how oral argument tends to go. They reframe at worst. They reframe what you said into trying to be more favorable to their argument. That's why it's an argument. It's your duty to correct that. The problem is he alleged some of these things in the fact section, but he never tied them to a cognizable claim and requested relief for it. Those are two very different things. He said it happened, but then in the counts, they didn't allege why, like under what clause or statute that these violations occurred and deserve court intervention. And that's where he failed.
To try to highlight what this is, just imagine the complaint is exactly as it is with all the facts, all the things that they say happened. And then they say, well, what law was violated? The Copyright Act, just to throw out something random. I mean, it has nothing to do with anything, but that's the point. It has nothing to do with anything. It's like, oh, here's a whole bunch of violations that happened. We weren't allowed to observe. These ballots weren't verified, blah, blah, blah. So here's a whole allegation of facts. And our cause of relief is the Copyright Act. Well, what the hell are you talking about? So that's exactly what's going on a little bit less dramatically, but they didn't put in a cause of action that has any relation to the factual allegations. Or more specifically, they took it out because it was in the original, and then they amended it out, and then they went and amended it back in. And the court said, how about hell no? And I'm kind of with the court on that one. Because what the hell are you even doing? Can't you make up your mind? You're amending and amending and amending within the scope of 3 days. What are you even talking about? Maybe get your game together. That might be good.
And
Again, I have to go back to an earlier point because Giuliani was the fucking man back in the day. He was the goddamn fucking man back in the day. And I don't know what happened. And it makes me kind of concerned about myself because what does this mean for me?
You're toast.
Maybe at some point in the future, I'll be this. And can I prevent this? You know, it's like looking at Bobby Fischer back in the day and then what Bobby Fischer became. Am I fated for that kind of thing? So I don't know what happened to Giuliani along the way, but all I can say is
28 years without being in a courtroom.
But there's lots of great attorneys who are old. There's a lot of great judges who are old who do fantastic work.
He was out of practice, out of any kind of practice where his feet were actually held to a court standard for 28 years. Entirely running PR and political campaigns for 28 years.
Does he not have 28-year-old memories? Apparently not, I guess.
I don't know. I mean, he just sounds really rusty. But to build on your analogy, let's say that they dragged you criminally into court and they said, here are the facts. Uncivil Law entered a dwelling that he did not own. He went inside. He grabbed a television from the dwelling. Mm-hmm. He removed it to his vehicle and he got in and drove away. And you say, okay, assuming all those facts are true. And they never say what law you violated though.
Yeah,
because
right. Yeah.
Because it turns out it was your parents' house and they asked you to remove a TV. And so they never. Okay, so what law?
Or it was my house or whatever. Yeah,
right.
Exactly.
It's the same thing that they're doing here. They're not alleging the actual cause of action and why the court should intervene. Okay, here we go.
Yeah, it's like you saw me breaking into this car and in order to drive it away. Well, if it's my car, it's not a crime. You know, my keys were locked inside, whatever. Yeah, let's press on.
Automata says, hi, I'm Nick Arcada, and I'm here to tell you how Trump can still win. There are a couple of easy steps. Now, do you remember that alternate timeline from Fringe? Well, Trump lost there too. Doom pills for all.
Delaware County observers were denied access to a backroom counting area. Other Pennsylvania counties provided appropriate reviews. However, in defendants' counties, they were denied the opportunity to have an unobstructed observation and ensure opacity. I'm not quite sure I know what opacity means, but probably means you can.
Okay, I have to be fair. I actually didn't know what opacity meant either. So I will give him that one. Okay.
It's not that he doesn't know.
But where he was asked about what standard of review I should do, and he said the normal one, that I'll criticize him on. Because that's a legal question. He should know that cold. With a random term opacity, he doesn't know that word. Okay, I'll give him a break. When he's asked what standard of review, the normal one, like rational basis, what are you talking about? Yeah.
My problem with this is he's reading off the complaint that he clearly didn't write. I mean, you guys have to remember, he joined that case this morning. He was added to the case this morning. He filed his certificate of representation and his petition for pro hoc vice, and he showed up in court that morning. He had not been on the case before, and he's reading a petition, and he's making arguments, and it looks like he didn't read the petition. I mean, prior to making
I'm just a simple country lawyer, but what might be helpful is reading the complaint or reading the file. That might be helpful.
Yeah, it would have been. And then asking your assistant what opacity means if you're going to raise it in court. But, okay, here we go.
See, right? You can see one. Look.
I think it means you can't.
It's a big word, John.
Judge, I think it means you can't. Yes, it's the root word is opaque. So it means it's not able to be seen through.
Once you break it down to the Latin, I get it. Right, opaque.
Yeah, I just love
opacity. I don't understand, but if you said it comes from opaque, I'm like, oh, okay, of course it does.
I just love that the judge says, "Well, I think it means you can't." It was a very nice way to approach it.
No, it's for me too. Let me move to my next.
And I have one last point, Your Honor. Those allegations, which take up 5 pages, and also allege, as they said, we didn't allege a specific amount of ballots. I don't know, 680,770 sounds pretty specific to me. That's number 142. And finally, all of that is incorporated by reference in the first count, denial of due process.
Let me thank
The first count wasn't denial of due process. The first count was equal protection. And just because you rolled the factual allegations into it doesn't mean you made a single argument as to how those ballots are impacted by equal protection, because you didn't. Okay, sorry. Mild criticism.
you. What-
Well, just to, Your Honor, you asked me to be helpful to the court, and just to circle back to your original question, because I think we got off on a tangent. We do believe our equal protection claim is well established and strong. And it should not only survive the motion to dismiss today, because that's what we're here for today, but also warrant the extraordinary relief of the preliminary injunction. And that's why we're here today. State law can say count certain votes, and it can say discard certain votes. It can say that. But what it cannot do is say under the U.S. Constitution, count some votes, but don't count other votes depending on where you reside in this Commonwealth. And that's what happened here. And that is the simple issue. And I know that today it went off into other issues, but that is this issue why we're here today.
She just, in 2 minutes, summarized the argument better than Rudy did for, this entire time. Unfortunately, it's not enough. It's still not a great argument, but it's a better delivered argument and more coherent than, what is this then? What is this? You'd have to be crazy. That's not the way to do it. What she did was succinct and was great. Why wasn't she arguing this? She had filed her motion to remove herself from this. That's Kearns, I think is her name. She had filed a motion to remove herself from this case. She is handling the lower court cases in Pennsylvania. She is trying not to remove it, and she said that was on agreement with the Trump campaign itself. So for whatever reason, she is not on the case anymore. The judge denied her request to remove herself for this hearing and presumably would grant it after, except that he dismissed the case, so it doesn't really matter. But he denied it because of this specific reason. He wanted someone actually familiar with the case present to be able to actually give some insight as to what's going on.
We believe that the equal protection violations are absolutely undeniable. And the fundamental question that you have in front of you is how extensive and how pervasive are those undeniable violations? And at this point, if you go through the pleadings, the defendants are flailing and they're grasping at any excuse not to answer those really simple, targeted questions that we asked. We're just asking that the defendants be transparent, and the stakes are high here. The stakes are very high here, and we're asking the defendants to be transparent immediately because there is irreparable harm. So to the extent that you're talking about all of the votes, today what we're talking about is the motion to dismiss and the preliminary injunction to get us through to the hearing on Thursday, when Your Honor can hear what we want to present with our witnesses and then decide those questions.
So she has done a much better job at oral argument just in the minute or two that she's been on, like I said. The problem is she's part of the team that screwed up the pleading. I don't know if it was her that screwed up the pleading, but she's the lead attorney on the team that filed the amended complaint.
And I also have to wonder whether or not they really screwed up the pleading, or whether or not this was some sort of dodge, that was like, well, we messed it up, give us another chance. Where's the buy time? Their credibility is so low right now. I'm not putting past some sort of maneuvering posture on them. So yeah.
Right, that is possible. So I just wanted to balance out my credit to her presenting better at oral argument than I think Rudy has done, at least on this issue, with the fact that she was on the team that has irreparably damaged the pleadings for whatever reason that they did.
Your Honor, we're asking you for a hearing. And as far as the remedy is concerned,
Judge,
once we have an opportunity to present the evidence to you, you'll decide whether or not the remedy is too broad, too narrow, the right remedy, the correct remedy, or you'll decide that our witnesses aren't telling the truth. But we no longer have an opportunity to go to the state courts. The Supreme Court of Pennsylvania has now decided that presence only means being in the room and not having an opportunity to observe, which would be in conflict with the law in 49 other states, which I believe does give rise. The man who was very angry at me, I forgot his name. He said that it's not a
That's
good
the guy we
equal
didn't listen
protection
to.
claim. Well, it's a darn good due process claim, since it is part of the fundamental rights in an election in 49.
Does he call out that they didn't raise a due process claim in the First Amendment complaint? Like he just said, it's a good due process claim. That's not in the First Amendment complaint, Rudy.
9 other states, and it used to be a fundamental right in this state. So that's a case that really gives us another claim that just arose today. But it can only be brought in a federal court. The state courts are virtually close to us now. We can't make this argument in state court.
Before I get to
Why
my
not?
second question, Mr. Donovan, you
Yes,
have something you
yes,
have.
I'll brief. Judge, I actually want to answer your question. Page 62 of the First Amendment complaint. Plaintiffs ask this court to enter judgment in their favor and provide the following: an order, declaration, or injunction that prohibits the defendant county boards of elections and defendant's secretary bookbar from certifying the results of the 2020 general election in Pennsylvania on a Commonwealth-wide basis. That means no certification of president, no certification of attorney general of the state, auditor, local races in the houses. That's what they asked for, Judge. So when they didn't answer your question, that's really problematic. And I think Mr. Giuliani is going to be more aggrieved because, in fact, he deleted his due process claim. So when he talks about canvas people, he deleted it. And when he talks about 680,000, it has nothing to do with the claim in this case. I know Mr. Giuliani wants to talk about his canvas that now is no longer a claim. It's not in the complaint before the court. And I do this, Judge, because I want to bring it. I've been before Your Honor. I appreciate it. But I'm bringing it back to this pleading, Judge. This pleading is defective, and they've asked you for extraordinary relief, so I wanted to answer that question. Thank you.
Thank you. Let me
I mean, again, hammering home the problem. The complaint was defective. You can't bring a claim into court without a... I mean, maybe you could make a motion for a trial court amendment to add a cause of action, and the judge would probably just deny it. The other party would
No, what they asked for
oppose
was
it.
another amended complaint. They asked for a second amended, and the trial court told them to go to hell. And I can't blame the trial court. I can't blame the trial court because I do the same goddamn thing. You don't even know what you're doing. It's so... Why was this deleted? Are you really saying it was pure error? Are you saying it was a mistake? Or is it because you're trying to buy time? I feel like you're playing games. You don't even know what you want. They went up to the Third Circuit, and it's like, well, our remedy, we want them to give us another amended. I'm like, hell to the no with another amended. You get one for free, and you took out your cause of action. I don't even know why, nor do I really care at this point. It's so...
Yeah, the question, I mean...
And these are supposed... The other thing that strikes me, because these lawyers are supposed to be the best of the best, right? That's what we've been told. Like, I don't know what I'm talking about because I'm not Rudy Giuliani. I'm not Sidney Powell. I don't understand the 4D chess of the Trump litigation strategy. They're supposed to be the very best of the best. And I look at this stuff and I'm like, I can't figure out what the hell is going on. So either I'm completely inadequate to judge this, which I suppose is possible, or they've completely lost the plot, which I think is more plausible.
Well, I don't understand why they amended the complaint in the first place. If there's a trial court decision or the Western District decision that comes in and invalidates the cause of action, just go into court and stipulate that those causes of actions are mooted by the other court's decision. And don't amend your cause of, like, don't get rid of your existing claims. Right. You don't need to. You can just go through each one and say, we agree that these elections and electors clause causes of action are going to be mooted or obviated by the other court's decision. Let's just proceed on this one, this one, this one. You don't even have to amend the complaint.
Just filed as a supplement as contrary authority. That's what you do normally. Just say, okay, in the intervening time, here has been a decision from some court that's contravening authority. Bring it to the court's attention. Just file a memo. and you preserve the issue. Why you would file an amended complaint, I don't know.
Yeah,
Because-
removing causes of action, especially, again, remember, I'm framing this in the context of their plan was to lose and go to the Supreme Court.
Which is a horrible plan. It's a sucky plan.
It is, but even if it is your plan...
I honestly don't know. I cannot figure out for the life of me why people think the Supreme Court's going to take this up. It's maybe because they think Kavanaugh got screwed. And personally, I do think Kavanaugh got screwed. I agree with you. And maybe Thomas got screwed. I agree with you. And maybe Barrett got screwed a little bit. I agree with you there. And Roberts got even a little bit screwed. Yep. So like you can see like the Democrats treated the Republicans badly. But you have to look at this from incentives. You have to look at it from even from a purely legal frame. What is the incentive of the Supreme Court to get involved on this issue if they don't have to? Why would they get involved unless it's going to change the result and the evidence is unbelievable? Because they're discretionary review. Why would they enter the fray? Because no matter what they did, once they enter the fray, no matter what they did, even if it's legally right, it'd be perceived political. Now, maybe they can't avoid it. Like maybe that's Bush versus Gore. They couldn't avoid it. And so they had no choice. But if they have any choice, why would they? They don't have to. It's a complete non-starter. So I don't know why people think the Supreme Court's going to come to the rescue. But if they grant the merits, I'd be amazed at this point based on what we see.
The argument for why is exactly what you said. That people believe it because they believe that the court has taken personally every slight that they've received, and that they are going to play partisan in the election, which I thought was doubtful. Which is even Barnes thought it was doubtful that ACB would play part in the election. That's actually one of the things he didn't like about her. He thought that she was less likely to intervene. But
and then I have to go back to a previous point, which is even assuming they would, do you really want them to? Because if they do it here, they set precedent. It means they can do it elsewhere. So not only won't they, but do you really want to? Do you fully understand the implications of that? I feel like they don't. They feel like, well, Trump will just get in office. It'll be glory. I mean, it's like, you have to think long term. We've been a republic for 250 years. You got to think a little bit past the moment. So I don't know. My hatred of everybody continues. We can press on.
One last point to go one step further. Even if you resolve all these questions favorably and you go, okay, they believe they'll get to the Supreme Court and they want to, you have to ask then, why do you amend your complaint and remove causes of action, thereby eliminating your ability to preserve them for the court? None of it made sense.
Let me ask my next question that sort of flows from the first. And again, I'll direct this to plaintiffs' counsel. You can choose who should respond. In the amended complaint, the pleading that I'm looking at, you repeatedly mention the dangers of voter fraud, in particular susceptibility of mail-in ballots to fraud. However, neither count in your complaint seeks relief from any fraud. Am I correct?
Your Honor, the amended complaint, as it was filed, seeks the specific relief that I mentioned earlier, which is
noted. So it's correct to say then that you're not alleging fraud in the amended complaint?
No, Your Honor, it is not. Because we incorporate by reference in 150 all of the allegations that precede it, which include a long explanation of a fraudulent process, a planned fraudulent process.
So you are alleging a fraud?
Yes, Your Honor.
All right. Well, if you've acknowledged at the beginning of the hearing that the only issue in the case is the equal protection claim related to ballot curing procedure, but you've repeatedly spoken now about claims relating to alleged violations of your right to have poll watchers present during the ballot counting process. Your poll watching claims were deleted. They're now not before this court. So why should I consider them now on oral argument when you deleted the claims and thus took them out of this action, something I think Mr. Donovan has just referenced? Remember what I'm bound to look at this point. I mean, that's what I'm bound to.
Okay.
Complaint's been amended.
What's your answer, Rudy?
Agree?
This should be
Oh,
good.
certainly, Your Honor. Yeah, it's been amended.
So since you claim that you're alleging fraud in the complaint, putting aside for a moment whether or not I think that's an accurate description of the pleadings, then this complaint has to satisfy the heightened pleading standard imposed by Federal Rule of Civil Procedure 9. Is it not? Something that Mr. Donovan is referencing from a prior matter that he had before me some years ago. So a private joke, I
Mr.
suppose.
Breyer was here too,
It's not even a very funny joke.
But, Your Honor-
but it's adherence to the rules, I guess, is what he's driving at.
What a
Mr.
hilarious
Donovan.
joke.
Yes, Your
Adherence
Honor.
to the rules is.
But I mean, isn't that it?
Yes, Your Honor, and I really have to correct what I said, because we'd have to interpret it to charge fraud.
Right. So
What it charges is the conduct in 132, 149 without character.
I understand that. So the amended complaint, does the amended complaint plead fraud with particularity?
No, Your Honor.
Ah! Are you pleading fraud? Yes, Your Honor. Okay, well, let me just re-ask you, because there's a heightened pleading standard when you plead for fraud. And if Rudy had any sense there, he realized that that was the death knell of his case immediately, and he thought maybe if he could walk it back, he could try and sneak in fraud without saying it's fraud under the lower pleading standard.
That's
But
what
then-
he's trying to do.
But so to his credit, he was at least thinking on his feet. But there he just said, I have to correct myself, ... No, not fraud. No, not fraud.
Right, because different things have different legal standards, right? We have standard what's called notice pleading in federal court and most state courts for that matter. You just have to provide notice of what you're alleging. You don't have to provide any particularities beyond that. Just a general allegation, general facts will be fine. Some things require more. And one of those things that require more is fraud. And he didn't do anything like that. Not for at least the reasons he deleted it from the complaint. And even in the original, I don't think it was specific enough, but we'll look past that. And then he says, well, is it specifically pled? And the answer to that, of course, has to be no. It's like, no. It's like, well, there are rules. Lawyers should know something about rules, kind of something we live by.
Mm-hmm.
And you didn't do that. So therefore, what's the right result, counselor? ... Right? So again, I don't even know where to start. It's like, it shouldn't be this hard. I don't know why it's this hard. I don't know what happened to Rudy. I don't know what's going on. I think it's because they have nothing, but why they're trying to go into court with nothing pisses me off a little bit because I expect more. And yeah.
Okay, let's do just a couple more minutes and then we'll wrap up because
no, whatever, it's fine either way.
And
we
it
can listen
doesn't
to
plead
more
fraud.
ranting.
It pleads the plan or scheme that we lay out in 132 to 149 without characterizing.
Understood. Now I want to talk about standing for a minute. I have some questions.
the judge politely said understood there, but that's not actually what their complaint says. He said that their equal protection claim pleads out the plan that they allude to in 132 to 149. It does not. It does not in any way do that. They just deleted the claim. That's the reality. So that's what the judge saying understood was pretty dismissive there for a reason, because if they are alleging that fraud plan or claim, they are held to the heightened standard. The judge isn't going to let him dance around it, and he's already, in his mind, at this point, this case has been dismissed, in my opinion. He's just going to let them finish their argument.
Standing. I understand that the new theory is based on the claim that the individual plaintiffs were denied the right to vote. You've stated that this is the injury your clients have suffered. In the amended complaint, you allege that the individual plaintiffs tried to vote in Lancaster and Fayette counties, but by your own admission, it was those counties that rejected those individual plaintiffs' votes. So why are you before me in this court suing the defendants for something that Lancaster and Fayette counties did? In other words, why didn't you just sue the counties that actually caused your clients' injuries? We talked about this a little bit, but that was addressed by the defendants, but I'm not sure specifically by you. You want to take that up?
Sure, Your Honor. The violations or this issue was triggered when we learned after the election that certain votes were counted and certain votes weren't. in terms of certain voters were given the opportunity to cure and certain voters weren't. And those voters lived in different parts of the Commonwealth. And we believe that we have standing in this court, in a federal court, because the alleged violations of equal protection turn not on transforming the state law into a federal question under the Third Circuit case that we've been talking about, but on the unequal treatment of the voters regardless of what the state law says. So we're not asking you about state law, we're asking you about the equal protection claim. And like I said before, state law can say what to count or what not to count, and that's not an issue here. It cannot say that the U.S., under the U.S. Constitution, that they're going to treat different voters differently, and that's what happened here. If you lived in Philadelphia or another county in the north or the west of the state, your vote was treated differently. And the gentleman from the NAACP talked about a woman who was notified apparently that she had sent in her ballot and there was problems with it, and she was able to get to the voter registration office and fix it. And that was a compelling story. But we have a compelling story in our complaint because our two plaintiffs did not even know there was a problem with their ballots until a couple days after the election. So they did not have the same opportunity as a plaintiff, as a voter in a county where they were being told in some type of a pre-election day review of ballots that there was a problem. So that's what this issue comes back to, the unequal.
But again, the defendants, even taking their equal protection claim at its word, the defendants are still their counties that failed to follow the process that other counties were following. Their remedy is not the counties who did the thing that was permissive. Their remedy was to go after the county that didn't do the thing that they could have done. That is still the violation of rights. The violation of rights is not done on the other person by the other county. The other counties have no impact over these defendants. And whatever's going on over there is creepy. I thought you weren't drinking enough wine.
I'm fine.
And that's why we have standing in this court. It's under the federal constitutional claim.
Your Honor, if I may, interestingly,
please.
On page 54, the new number is 127. I think the issue that she's describing is really very clearly laid out, because it says in Philadelphia County, they were allowed to cure, particularly a lack of a secrecy envelope. Well, that's exactly why Mr. Henry's vote was declined in, I guess it was Lancaster County. Yes. And whether one...
But Philadelphia County didn't deprive your person of their right to have a cure, because that's what you're asking for. That's the unequal treatment. The unequal treatment almost never is that someone else got more of a right.
Right.
It is possible theoretically that a state or a municipality or whatever giving someone more of a right could be an equal treatment claim. It's really hard. Almost always it's that someone got the lesser end of a right. And so again, his defendant should be the county who deprived him of his right to cure, not the county that granted a right to cure to someone else.
Yeah, particularly when you're talking about these kinds of numbers. So normally when you're talking about someone else got something I didn't, you're not talking about this kind of number. So it's more obvious. The problem is the dilution. There's so many voters, so many people. It's like, I didn't get something. And even going to the next step, if you got it, would it matter is the next problem on top of this, because if we cured every ballot, would it matter? Again, we're talking about an 80,000 vote disparity. That's what we're trying to fix at the end of the day. How are you going to get there? It's not obvious.
Well, and if you, to contextualize this, because equal protection is weird in concept, but let's look at it this way. If the civil rights movement was suing under the 14th Amendment because blacks were being treated worse than whites, the comparative case to this would be them asking the courts to demand worse treatment of whites. not better treatment of blacks. That is the remedy that they're asking for in this case. They're demanding that everybody be given a restriction on rights, not an expansion of rights. That's what the Giuliani team is asking right now. Look, blacks are being treated worse than whites. Let's bring whites down to the blacks level. That's not a winning argument in court ever. It's just not going to happen.
One is legal or not, as Ms. Kearns points out. I believe it is illegal to cure. I think the law of the state says that.
That's a state court claim. Challenging the validity of the secretary's notice to counties to extend an opportunity to cure is a state court challenge that was brought up by the defendants, and they're right on this. This should not be in federal court for that issue. If that's what you're saying, you're in the wrong court.
Yeah, most of these are state issue because, again, the Constitution gives the authority to the states the time, place, manner of elections. And these are state issues. And trying to cram this into federal court is hard to non-starter. And this is exemplar. These issues are kind of routine in the grand scheme. We can look to other elections, other examples, the other kinds of things that have been done in the past. And these kinds of things they're talking about are kind of part of the norm. Again, because we deal with this on a state level, if not a county level, if not a precinct level. And there's so many different authorities that you expect this. And these kind of routine things does not an equal protection claim make. So.
And in fairness to the legal teams, if you put this before me and said, how do I bring these claims? I wouldn't be able to tell you off the top of my head. So no one is expecting these people to know like every standing argument in federal court related to elections and equal protection. The problem is that it was these people's job to find these answers, and these answers are not hard to find. There is only all of the case law around these issues. A Westlaw search will hit you with hundreds of results about how equal protection claims are pled in federal court, especially with regards to standing. In fact, if you go on Westlaw and type in equal protection, you'll get a list of cases, and then you can actually break it down into the subheading of standing. And you can look at tons of them and find out, can I even bring this? Can I bring this type of issue? Can I bring a state law election claim in federal court under equal protection when I'm challenging the implementation of the law? You'll find the answers very quickly. No, this is where, and this is what they're paid. You know, I don't know what they're being paid, but I would wager that each lawyer at that table, especially for Trump's team, is being paid $1,000 an hour or more right now.
Probably.
It's an insane amount of money. And all they had to do is do some research.
I don't think the secretary has a right to vary that, but that's irrelevant to what we're arguing right now. What we're arguing right now is if you set up a system that allows cure, you can't have the system for the northern part of the state, but not for the southern part of the state. You can't have it for Philadelphia County, but not for Lancaster County. That's exactly what Bush v. Gore is talking about. That is about as classic a case of denial of equal protection with a sacred right, the right to vote. It can't be played with that way.
No.
And I think that's the point.
Not at all.
Okay. I recently covered Bush versus Gore on my channel, so you can go watch a video from me. In fact, I released it on Election Day.
Go do
why
it.
Not? Yeah. But Bush versus Gore was about the fact that state Supreme Court ordered a recount. And because it was a singular authority ordering it statewide, it needed to be uniform. Bush versus Gore did not deal with what happens when county level authorities or precinct level authorities are issuing different regulations. It didn't deal with that. It dealt with specifically if a singular state authority, namely the state Supreme Court, was issuing a recount and ensuring there'd be some standards. So Rudy Giuliani is just misunderstanding, misquoting. In fact, not only that, Bush versus Gore made a specific point of specifically saying it wasn't dealing with this issue about localities or the precincts or the counties with the different things. It mentioned it explicitly. So him saying, well, this is Bush versus Gore, is not only contrary to the holding, it's contrary to specifically what the Supreme Court said specifically it wasn't dealing with. So all I have to say to this is you don't understand Bush versus Gore. Yeah.
It's true though. It's true. And again, the remedy in this is to have Lancaster County offer notice to cure. And specifically, the remedy for these two plaintiffs would be to offer them a one-day window to turn in an absentee ballot. Like, that would be it. Okay, you go turn in your ballots and we'll count them. Because the court would know that it wouldn't have any impact on any election and it would be just fine. That would be the remedy. And if they screwed up that ballot, they'd get notice and an opportunity to cure. I don't know if the court could even grant that remedy, but if they could grant a remedy, that's the one they would do.
That would make it. I think that's an unassailable equal protection claim for the two plaintiffs, particularly Mr. Henry, who happens to have done exactly in his county, where he was denied the right to vote, what happened in Philadelphia, where they were given the right. And it's the Commonwealth that is counted.
Well, that's what I'm driving at. So why is Secretary Boutenvar here? I mean, you don't allege that she personally rejected the plaintiff's votes or had any authority to do so. So could you explain how the Secretary of the Commonwealth's actions caused Lancaster or Fayette counties to deny the plaintiffs the right to vote? How did Secretary Boutenvar's actions affect these individual voters in Lancaster and Fayette counties?
Right, Your Honor, if you review our motion for a temporary injunction, you'll see that the Secretary periodically put out guidance. And the Secretary is not an elected official and does not have the authority to interpret the law or change the law. And periodically
State law claim.
Put out guidance. And not all counties, it appears, might have followed it or had the ability to follow that advice. And the night before the election, apparently an email went out to the counties from the Secretary of State's office. It was not made public. It was not public guidance. And it told the counties, I think it went out at 8:38 p.m. from the Secretary of State's office, telling the counties to, during the pre-canvass the next day. And pre-canvass is when that was the first time anyone was supposed to start to look at these ballots. Under the Pennsylvania Election Code at 7 o'clock on Election Day, that was the first time anyone was ever supposed to look at these ballots. So that triggers, well, why was everyone looking at the ballots before Election Day? But then when the Secretary's office put that email out the night before, first of all, it was 8:38 p.m. when it got put out. And some counties apparently followed it, and some counties apparently didn't. And our plaintiffs are a great example because no one told them, no one asked them to come in and cure their ballot or that there was anything the matter with it. And they didn't find out until a couple days after the election. And Your Honor says, well, why didn't they sue their county? Well, you sue their county afterwards to say that their ballot didn't count?
Yes.
So the issue here is that the guidance and...
Well, yes. Yeah.
Did you hear the silence?
I did.
Oh,
I heard it all.
It was beautiful. It was beautiful.
It was.
Well, yes. And then...
Yeah. I thought your laughter was an appropriate reaction to me. It's just like, I can't deal with it. It's so, yeah.
It was like, yeah. I just love the way he did that. That cracked me up. That might have killed me. All right, let her finish, and then I'm gonna have to end this because it's getting late.
You're killing me.
I'm sorry.
Each individual, well, Your Honor, and that's why...
Isn't the remedy ultimately in the Court of Common Pleas of Lancaster County and the Court of Common Pleas of Fayette County, or the appropriate, state judicial districts? I think they're individual. I think those counties make up their own judicial districts, if I'm not mistaken. Correctly.
That would be...
Isn't that where you go?
That would be a state law claim. That would be...
Yes, it is. That's the point.
Telling the county, you didn't treat my individual vote correctly. What
That's literally what they're arguing. You didn't treat my individual vote correctly.
It's a state law claim. Ding, 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 ding. That's right. It is a state law claim. Fucking bullshit. Unbelievable. You came to the right answer. Unbelievable. Wow. God.
Okay.
we're here today, though, is an equal protection clause, an equal protection argument for all citizens of the Commonwealth, that all citizens were not treated equally. So that is different than just simply taking it to a county under a state law claim after the election. What's before your honor today is that because of the actions of the Secretary of State and the various county boards of elections, voters were treated differently. And that's what's in this federal court today.
Let me switch gears. And I want to talk now about the Trump campaign.
Real quick, voters are always treated differently. There are different amounts of polling places. It is harder to get into. You may stand in I've never stood in a line for an election, and then I look at like Detroit and Philadelphia, and people stand in line for 6 hours. I don't even know what that is.
Yeah.
Voters are treated differently all the time. All the time.
That's exactly right. If we're going to do this full bore equal protection thing, if we're going to go all the way to the end of the page, let's apply it equally. So let's talk about the fact that there are long lines in more poor areas, and shorter lines in richer areas. And maybe that's an issue too. I mean, you could go everywhere, but a lot of this is just par normal. It's part of the normal background. And as she kind of pointed out, or as a judge pointed out, it's state law issues. The states, okay, let's just try to go back to the beginning. The states choose the time, place, manner of elections. It's a state law issue. Why are you in federal court? You're trying to dress this up as equal protection. You were trying to say it was fraud. Then you said it wasn't fraud. Now you're trying to say it is fraud again or something. I don't even know. But these are state law issues. Deal with it on a state level. I mean,
what's funny is they have a glaring.
It's painful.
They have a glaring federal issue staring right at them, and that is the acceptance of a ballot in violation of the state law, in violation of the federal law around the time to accept ballots. They have it. Yeah. They have it in Pennsylvania. It's already sitting before the Supreme Court. They can just revive the issue. But I think the problem is when they segregated the ballots, or if they didn't segregate the ballots, again, a Supreme Court issue that they could take up because the court has reserved its jurisdiction in that case. The problem is they don't have enough ballots. They don't have enough ballots that came in after Election Day to overturn an 80,000 vote deficit in Pennsylvania. They just don't have it. That's the problem that they've got. But that would be a federal claim. There's a federal law. It's a federal constitutional issue. And if you have states trying to exceed their authority to extend the deadline beyond the deadline that the federal Congress sets as reserved in 3 USC Section 1, then you've got a federal claim. And they're not bringing that in federal court because they don't have the votes, is my opinion on why they don't do it. I don't know if they actually don't, but that's my opinion on why they don't. And they should be doing that in Michigan. They should be doing it in Pennsylvania, Georgia, and Wisconsin, because all of those had vote dumps after midnight on Election Day. That's what I would be targeting. It's not the best shot, but because they could say, well, those votes were turned in. It was just the transportation of the votes. Yeah. And I would make the argument that per election law, per precedent in the United States, I can't remember the citation, but a vote is not actually cast until it is in the hands of until it is in the official ballot box at the counter's office. It's like, okay, well, if it's not there by midnight, then it's not there, and those votes are out. Well, then you get rid of the late night dumps that that's what I'd attack. It's a hard claim to win, but it's easier than these. At least it's in federal court.
Yeah, I think the federal law issue is a little bit more ambiguous than you allude to. The state law issue is a little bit more clear, but the Pennsylvania Supreme Court is master of its own law. And the Pennsylvania Supreme Court apparently thinks that what's clear isn't clear. So I'm not sure there's a role here. Like, even if the Pennsylvania Supreme Court fucked up, you can't appeal a state law issue to a federal court. It doesn't make any sense. We have separate sovereigns. We have federalism. These are concepts that should be familiar to Republicans. Republicans believe in this. Separate sovereigns, federalism, state level control over state level issues. Why would we apply this any differently now than any other time? If the Pennsylvania Supreme Court says black is white, there's not a role for the federal court here because it's a state law issue. Okay, let's press on.
Okay, yeah, let's see what his next question is. I'm sure it'll be easily answered.
Equal
The
protection claim
Kraken's in the next question, I'm sure.
against the defendants, which you've just referenced. Can you clarify whether the campaign is bringing its own equal protection claim or whether the campaign's claim is derivative of the individual plaintiff's injuries?
It's a trap.
Follow my question?
I think I follow.
It's your statement to me, your argument just a moment ago, sort of is a lead, it seems to me, into that.
My answer,
So is the campaign's claim derivative of the individual, you have two individual plaintiffs' injuries?
my answer would be, it would be both. That it's derivative of the individual voters, but the campaign is also suffering an injury because and remember, we're here today.
What is the injury?
Of the voters or the campaign?
The campaign.
That the votes, that because of the unequal treatment of the voters across the Commonwealth, certain votes were counted properly and certain votes weren't. Because if we don't, and this is the subject of our term.
Real quick, your right to vote is individualized. The Trump campaign is not aggrieved by an individual's right to vote not being honored. So even given their claim that an individual's right to vote was valid or was violated, and that claim was valid, your right to vote or the Trump campaign has no right to that individualized right. They don't have a right to the fruit of that individualized right. You have to come up with a different cognizable injury for the campaign, and that's where I believe the judge is going to hammer them, and I think he does in the opinion. Anything to add to that?
No, it's like you just can see the writing on the wall. Nothing makes any sense, and this is in my view, and I think Nick agrees with me, but he'll correct me if I'm wrong. This is emblematic of so many of the lawsuits where there's really nothing there. You test it in court, as so many of these things have.
I literally wrote this in the
apart.
description.
It falls apart. And it's like, it's nothing makes any sense. It's ship shot, rough, incoherence. Nothing makes any sense. And the state government representative is there like, what the fuck is this shit? I'm kind of with the state. And I have respect for various lawyers like Rudy back in the day, and I just evaluated on the merits. And I don't know what the fuck is going on. It hurts my soul.
Did you must have, well, I don't know. I shouldn't accuse you of this. I literally used the word emblematic in the description of this video, by the way. So we're fully in agreement.
We just think alike.
We're fully in agreement on that one. Okay, I think I gotta be done with this. It's not just beating a dead horse at this point in time. It's walking around on the corpse of the horse.
With all due respect, I think we were beating the dead horse when they started the argument in the introduction. You were there when the state was presenting its argument. I saw your stream last night, and the state started its argument, and you're like, "Well, we're kind of done." And I'm like, "Yep, we're done. We're done." Sometimes you're just done. I did on my own channel. We do Supreme Court React. And I'm like, yeah, we're done. First 2 minutes, we're done. There's nothing left to be said. We're done. Why are we still here? And I'm like, yeah, this is one of those things. It's like, it's clear, it's unambiguous. And the district court's opinion that came out is right on line. And I can see why there's nothing here to be had. And I'm sure someone will say, but the 40 I should have said 40 chess of the Trump campaign will manifest today. Surely they know exactly what's going on, and Trump will be sworn in January the 20th of 2021. Yeah, that's not a thing that's happening. So you better clench your buttholes real tight because Biden's coming into office.
He is. And you're right. The reason I persisted on, though, is because I think it takes a deluge of information and evidence in the face of the media blitz that's going on to get people to realize, like, just how bad this has been. It can't be overstated. And the fact that they have even a PR machine now reverse prophesying their own losses as part of the plan, and that's official messaging from the legal team is embarrassing. Your plan should never be to lose so that you can win later. Just win now. Just win now. It's the better plan. 10 times out of 10, I cannot think of a time where if you can win, that losing is better. It just doesn't make sense to me. But
I see 501 likes, so I owe the chat some winks. Yeah, winks time. Yeah, you know what's going on. Winks. Yeah. I wink for you, baby.
I'm gonna turn off my camera. This is horrifying.
I wink for you. Yeah, the Ricky and Chad. Yeah, let me wink for you. Oh, wink all night long.
Well, I finished. All right, let's read these chats and then let's wrap up. Are we gonna do something tomorrow?
Yes, on my channel, I think.
Yes. Okay.
Yes, we will be on my channel tomorrow after 3:00.
You had originally said 5.
5 o'clock. Yeah.
3 is probably fine. I think everything in my life is canceled right now. So let's just go. Wait, no. 3, I have live chat Wednesday. 5 is better. Is 5 okay?
Yeah, it's fine.
Okay, 5 o'clock Central Time over on Uncivil Law's channel. I'm not sure what we'll be talking about, but I'm sure it will be great, whatever it is. So guys, come hang out with us there. Don't leave yet, of course. We've still got the chats to do. We'll purge through these pretty quickly, and then you're free to go. There will still be a show tonight as well on my channel. It is going to be a Doompill free stream tonight. I think we're going to be talking about escapism and creation and fun stuff and maybe funny news stories that have nothing to do with the election. So, here we go. Jay says, I'm just here waiting for Biden to reverse Trump's allegedly racist executive order that bans racial stereotyping and scapegoating so that critical race theory can flourish and destroy federal agencies with his racial stereotyping and scapegoating. Yes, that'll be fun. Crusader Saracen says Beto for gun czar and Ilhan Omar for DHS secretary because, hey, why not, right? Yes, appoint Beto. Get Steve Buttigieg in there for something too. You gotta get him in there. Crusader Saracen says if people here are hankering for political prognostication, I'd love to see Razor Fist back on. Nobody better at it than he is, and I'm sure he'd have a lot to say about allegations of fraud in the future political trajectory. I would love to have Razor Fist back on. He's a very busy guy, so and our streaming times tend to overlap a little bit, so it's not always simple. But I will see what I can do. Someone was like, "It'd be great to see you debate Razor Fist on this." And I was like, "I don't know that we disagree on the issues. I think we might do. My take is just on what the legality of what they're bringing, or the legal aspects of what they're bringing, and they're just embarrassing." So, Respergu says, Nick, please help President Trump win the election. I did. I voted for him. It didn't help because I'm in Minnesota. And Minnesota did not go red. 200-Watt Studio says, Nick still simping for Biden. I'm late today. Unknown Existence says, do you think when Trump gets reelected in 2024, he'll follow AOC's idea and compile a database of Biden and Jorgensen voters?
Yeah.
Hopefully. Danny Grimm says, how is it anyway lawful for Democrats to turn election day into an election week? Don't polls close for a reason? What I will suggest is that I think there's an argument to be made, and the only case I can find on 3 U.S.C. 1 is a state Supreme Court case in Montana that interprets 3 U.S.C. 1 as to say that ballots have to be in by midnight on election day. No. That's how, but it's only a state Supreme Court and only in Montana, and it wasn't related specifically to that issue, but that was a ruling that the court had in that case. So I think it's an argument Obviously, a state Supreme Court agreed with that. It's an argument to say that any votes after midnight that are not at the actual collection office by midnight are not valid, which means you have to close the polls at 6 p.m. or whatever. But I don't think that the federal government can restrict the ability of states to set up early voting mechanisms based on the same clause of the Constitution. So I think you can have an election week. I, in fact, think you should have an election week to comply with the election day. I think that would be a better system than what we do now, where we're trying to cram everything in on Tuesday. But that's me. G-Man says Giuliani is a grower, not a shower. Swade's Lounge. Swade's Lounge says Georgia Senate races are rigged. There's no way Republicans will get those seats. It's entirely possible. At least now the eyes of the nation will be upon them, and maybe the Republicans will raise the issues at the beginning of the election rather than at the end. Cal Clay says Tim Pool thinks Trump leaves and just disappears entirely. The media that oppose will crumble in 4 years, and in 4 years he can suddenly rerun and win. Thoughts? I don't think Trump will have a chance to rerun and win.
I don't know. I can't foresee that plot. I think it's likely that he'll be cast off of social media. So Twitter will ban him. Facebook will ban him. I think it's likely. His own media company is a possibility. I think that's kind of the next step. Where that goes, I don't know. But I think the Republicans are probably better off without Trump in 4 years. So personally, and people will disagree with me, I'm sure, but I'm hoping for Nikki Haley. I like her quite a lot. She has flaws, but I think she's the best. She's the woman to lead us, and it would just be too rich for the Republicans to elect the first female president. So I'm kind of pulling for Nikki Haley 2024. So that's where I'm sitting.
I'm pulling for Uncivil Law 2024.
Yeah, I'm available. Let's go.
Joshua Worley says the ATF going after things like AR-15 pistols could result in violent conflict under Biden. It could. Gun confiscation is a very tough proposition in practice. So we'll see. Cal Clay says, rape Biden/Harris with 2 senators owned Zuck/Dorsey. I don't know what that actually means. But okay. Joshua Worley says Republican Congresses are good in the defense, like under the Obama administration. So there's that, but they do nothing in power. Trump was on his own. Mark Hamill says anyone saying it will be A-okay with a Republican Senate woefully doesn't appreciate one signature on TPP will negatively impact tens of millions of Americans. What's TPP?
The Trans-Pacific Partnership. It was the treaty that was pending at the time Trump came into play, where they're trying to deal with some copyright stuff. Excluded China was this trade agreement. It had some problems. I opposed it at the time, but yeah.
Okay, I remember the issue. I'm not familiar with the details of it. Midnight in Exile says Boogie cucked Pinky out counter signaling like uncivils cost us a lot of capital. It handed ground to the opposition. I don't think you were counter signaling up until after the election, which, let's be clear, guys, there was no ground to give to the opposition once the votes were in. Like there's no amount of messaging that would have changed the outcome of how the votes were tabulated.
Yeah, I mean, I lean much more heavily, at least I try to lean heavily on legal versus political. I have my own political views, to be sure, and my political views also lean Republican conservative. But for me, the conservative legal departs from conservative political. And the way I explain this on my own channel is, if we suppose that there was a proposition for a 90% marginal tax rate, if we suppose that, as a political figure, I'd be likely to oppose it. But if it came to pass, if it passed, and as a judge without more, I'd enforce it because it's within the power of Congress without more. Right. And so that's where I separate things. So I lean on the legal. And so when I was looking at things initially, I was a little bit more skeptical. As things have panned out, I'm like, there's just nothing here. I'm just trying to do the legal analysis. And what I wish would be true would be a more conservative, more traditional Republican philosophy. I'd like Trump to be in office. I voted for him. I'd like that to be true. That's my political preferences. But again, separating political from legal, what I try to do, I'm looking at this from a legal proposition. What is the legal posture? And I'm not seeing it. It's not because I don't want it to be true. It's because I'm just looking, it's not there. So, at some level, I don't know what to tell people. I'm reaching the analysis I'm reaching despite my own interests. And I don't know what to tell people. It's like, what do you want from me? It's what I see.
Well, and importantly, our legal analysis, our motivation is irrespective of the actual lawsuits outcomes or the vote counts outcomes. There's no, and everyone's, except for the actual lawyers and judges bringing cases, everyone's rah-rahness doesn't do any, it has no tangible effect on how things work. There was no ground to give. Once the election happened and votes were in, that's it. And prior to the election, I think we were both pretty adamantly in support of Donald Trump. I'm not like a crazy fanatic for him or anything, but he's the guy I voted for. I said why several times. I said I didn't vote for him in 2016. I think he earned my vote through his 4 years. So I don't know either. Nate Dogg T 1998 says, in the neo-corporate future, I side with Amazon. Yoru Kama says F for Hong Kong and Taiwan. Cal Clay says Trump should buy Amazon stock, $3K a share and rising. Jeez. 200-watt studio.
Let me just say one more thing.
Oh, yeah,
if
of course.
I can. I'm not saying that I'm perfect. I'm not saying I'm God. I'm none of those things. I could be wrong. I'm just one man trying to present an assessment. And maybe someone will present something. Maybe it will blow all our minds. And if it happens, I'm more than happy to cover it on my channel. I'll be more than thrilled. I've been wrong before. I predicted things wrong before. Kansas v. Glover being a famous example on my own channel. I predicted 6v3 Glover would win 6-3. He lost 8-1. So I got that pretty much backwards. So I'm not God. I'm not saying I'm infallible. I'm just saying this is my assessment. And maybe the future will prove me wrong. But I'm just trying to do the best I can and give you the honest assessment for what it's worth. So judge it for its merits, right? We're just trying to judge it as we see it.
Both of us would probably be happy to be wrong on this.
Yeah,
it would be great.
Happy to be wrong.
It'd be hilarious. Great. I think it'd be the funniest thing on earth.
The hilarity, the Schadenfreude, if I'm wrong, would be so unfucking believably real. I'd be so fucking happy to be wrong. And I would say how happy I'm in to be wrong, and I would revel in the tears. I would revel in the tears for days. So I'd be happy to be wrong. And maybe I am wrong. I guess we'll see. But I don't know. I don't know what else to do but give you an honest assessment.
Only when the Kraken is unleashed. 200-watt studio says, I miss Sarah the lawyer. Get her on the show, Nick. Look, I don't know if she could deal with the chat's abuse. Robert Levito says, trust the plan, guys. We're serious this time. Definitely a plan. By the way, Sarah the lawyer was one of the lawyers in that Sophie Long case, the little girl down in Texas, between the two parents. She was pretty. She was a pretty lawyeress, so to speak. So I got lots of requests to get her on the show.
As to that, I say, sup, girl. Sup, girl. Contact me.
We'll get her on the show somehow. Austin Heartless says, have Tim back on. I would be happy to have Tim Pool back on. He's got his own machine going. He's doing great. Esme Illis' anime says, Nick, Jesus, get Tim on the show before Legal Eagle does. Oh, no. Legal Eagle has no interest in having a Tim Pool on the show. I don't think. Keck7Go says, Nick, check your Discord DMs, please, and thank you. I did, you son of a bitch. Tommy Z1052 says, what is the remedy? How many election rules? No signature checking. Can they just violate even more rules going forward? Should we just surrender? I have to point out that the no signature checking claim has not been properly brought before any court. So they've just said it. They've never actually alleged it, presented evidence on it, or brought it as part of a cause of action. So we can't assess whether or not it actually happened. They say that it happened. I don't think it's that far-fetched that it did, but we can't test it. If we can't test it, we can't test it. I don't know what to tell you. Dragon's Treasure says, is Rudy doing the best he can with what he got, or is he being an idiot? His tone of voice is really getting on my nerves. I don't know. Tommy Z1052 says, could Trump represent himself and benefit from deference of the court to applicants who are pro se? No.
Nice idea. I like it though. That's nice.
No.
No, I do like it on a humorous level, but no. Yeah.
We got the best fraud claims.
It's too rich. It's too rich to imagine, right?
Yeah.
The best fraud claims, the superior fraud claims, you're gonna love it.
Bad Dragonite says, that's it. I'm subbing to Legal Eagle with a sad emoji. Cal Clay says, Nick, Trudeau going to make us Venezuela. Wealth tax to pay off $300 billion deficit in Biden's speech. War on Russia and Korea. Now drafting Trump voters and supporters by force. God, I hope not. Track Media only says, am I remembering wrong? Didn't Alito or Kavanaugh order them to keep late ballots separated and they refused to do so?
Yes, Alito did as a precautionary measure. So let's just deal with the legal background here.
Yeah.
So the Supreme Court dealt with a motion on the injunction. So injunctions are discretionary. They're equitable remedies, not strictly speaking legal. And the Supreme Court split 4-4 on the issue of holding over the ballots. Then the Secretary of State said, we'll hold over the ballots from the time that they received after Election Day. Alito, who is a circuit justice, I believe still is, because they just reassigned it, but I believe he still is. Alito said, confirmed the Secretary of State, just said hold them over. But those are all they're non-merits decisions. So what I was saying earlier was, will the Supreme Court actually hear the merits of the issue? Will they actually have oral argument? Will they actually decide as to the operative issues? So they've issued these tangential orders, but will they actually get into the fray? My prediction is no. Alito said set them aside. My understanding, they were set aside. Some people said they weren't set aside. Some people said they were defied. My understanding from the Secretary of State was that's not true. They weren't defied. And so unless someone can prove they are defied, I don't imagine the Supreme Court getting involved. So you'd have to prove either Alito's order was defied, in fact, so they were counted when they shouldn't have been, which the Secretary of State says it isn't. And I tend to believe it because the factual posture is there. Or you'd have to get into the fact that it should decide the merits. And I don't see it because, again, the amount of ballots you're talking about that were received after Election Day, you're talking about 10,000 ballots, give or take. Maybe it's 20,000 ballots. Maybe it's 40,000 ballots. But it's 80,000 vote difference. Why would the Supreme Court get involved on discretionary review when they have the right to decide if they're going to hear the case? Because that's their posture. They can decide whether or not to hear it on cert. Why would they grant certiorari if there's 10,000 votes, 20,000 votes, 40,000 votes? If the gap is 80,000, it doesn't make any sense.
And if they were segregated, if I'm not mistaken, that means they're not counted in the results.
Right. So that's my understanding too. They have not been counted in the results.
And presumably, if they're late arriving mail-in ballots,
right,
they're presumably in Philadelphia, they're presumably in favor of Biden 3-4 to 1.
Yeah, I agree with that too. So, I mean, if you're talking about 10,000 votes, you'd say maybe 70-30 split. So it's 7,000 more votes for Biden, 3,000 votes. It's a 4,000 vote gap. I mean, why would the Supreme Court get involved if they don't have to? I mean, the actual legal issue is very interesting technically on terms of the legal posture, whether or not the U.S. Supreme Court can get involved in a state law decision because the electors clause of the federal constitution and or equal protection. It's a very interesting technical issue. But why would they get involved if it's not going to make a difference? They wouldn't. It makes no sense. So if the Supreme Court grants review, I'd be amazed.
Take it out, please. Sorry.
No problem. Was it my fault?
No. My son was asking if he could practice violin in the next room. I was like, please go somewhere farther.
Fair enough. I'm done.
Okay. Yeah, it's there's a lot of questions around what those ballots are, and there's a lot of conflicting information about whether or not they were segregated, and then another question about whether or not they'd have any impact at all. Keck7 Go says, react to Legal Eagle's bad election take video now. No. I watched a few minutes of it, and I hate it. Cal Clay says, Reddit coop restrictions. Posts involving 2+ people will be removed. This is no time for you to be so thirsty for sex that you risk yourself on others. Porn is banned. Automata says,
I'm in absolutely no sense attempting to speak to the validity or wisdom of what the Biden administration will do. Maybe they will impose massive lockdowns. Maybe they'll try to restrict us all. I can't speak to that. And if they do, that's another legal issue that I'll analyze. Whether or not they can do it, whether or not it's constitutional, right? That's another legal issue. The only legal issue I'm trying to decide right now is the validity of these ballots and who will be president. And if Biden is president and he does shit, we'll analyze those legal issues too. I'm not in any way complacent. I'm not in any way accepting. I'm Republican. I'm conservative. I like very much not for those things to happen. And we'll get into the legal issues, but the legal issues are separate from policy. And I don't understand why people can't accept this. It's pissing me off.
Automata says Trump's lawyer is going to have Nick waiting for 6 hours to vote at his polling place for no reason so that equal protection is given to Detroit. Bad Dragonite upgraded to super lawyer level. Hey, man, if you need an invite to... I think you're in the Discord, but if you need one, send me a message. Bob the Troll King says, how much do I have to spend to make him stop? More. Biden the Cold One says, at Uncivil... That was for your eyebrow winking, by the way. Biden the Cold One says, at Uncivil Law, I love your bedroom eyes. Brian Nateran says, Nick, don't bring back Uncivil Law. The stream can't handle his sexiness. Chris Gutierrez says, Nikki Haley tried to get us in a war with Syria. Renal Ryan says, DSP should have taken Rudy's place. Bug voting mechanics, dude. We did nothing wrong. We did everything right. I really need that money. I really do. Biden the Colden says, pay attention to Ken Jennings. Have him on again. We won't leave you alone until you do. Also, shill your other channels again. I'll do it tonight. Gerard Garvin says Trump can still win if he tweets hashtag Gamergate, which is true. That's a definable fact. The Pie Baker says, gents, at 6 p.m. on December 1st, 2020, we all need to Google why is my P red to F with the computer overlords. Sounds good. And Malik Foxon says, the conversation in chat is all kinds of fun. Have you been watching? Lots of back and forth in the chat, and it's great. I've been watching a little bit. All right, guys. Thank you for hanging out with us for your daily dose of doom pilling. Come back at 11 p.m. on my channel for a non-doom pill stream. Also, check out me on Uncivil Law's channel tomorrow. Should be 5 p.m. Central. I'm sure we'll announce it when that's all ready to go. And looking forward to that very much. If you have not subscribed to Uncivil Law, please go check out his channel and hit that subscribe button. Brian Nateran says, Uncivil Law / Ricada Law 2024, they bring the racket. So there you go.
We could do worse.
All right, guys. Thanks for hanging out with us today, and we'll talk to you soon. Bad Dragonite says, subbing to Legal Eagle has made me a super lawyer. Cal Clay says, Trump leaves and take Tarantino. Pussy. What? All right, guys. Have a good day. We'll see you later. Peace.
Peace.